pertaining to the Passenger Rail Agency of South Africa, otherwise known as PRASA, and the Road Accident Fund. Am I correct? I am not misdirecting you, and you are here to talk about Northwest Province. Uh, so I think we've seen each other a few times. So, and I think we know your team, Advocate Motibi. But I suppose for the record, you might want to do that. Just some housekeeping issues. So, at 1 o'clock. In this same meeting, I am going to move from the chair and sit somewhere else because all the portfolio committee chairs will have a meeting here. So we have to finish at 1 o'clock or just before 1 o'clock. So we're targeting 1:45. So if we can do an equal division of time between the Special Investigating Unit and the Office of the Auditor-General, I am hoping that say at 11:45, or we are able to take a short break and then resume at 11 o'clock. The documents were sent ahead of time. Thank you very much for that. We really appreciate it. So take them as read and assist the committee with the most important issues that we need to walk away with as we go on oversight in the coming weeks. Thank you very much, Advocate Matibi. Over to you.
No, thank you. Thank you, Honorable Chair and honorable members. We will start the presentations with the PRASA presentation. My colleagues, as you said, Chair, I mean, we've been here several times. They'll introduce when they come in. As part of the background, and I won't go into the contents, as part of a quick background on PRASA, we've had an investigation that was going on at PRASA for a while, and we're covering that investigation later on in the presentation. The one that we really start off with, it's the one that we initiated as part of the implementation of the Zondo Commission. And that slide that's there, the first bullet point, really just says, as part of the Zondo Commission, you'll recall that the report of Zondo Commission was, amongst others, recommending that the President establish another commission to dive deep into PRASA. And the diving deep, as they put it, was to investigate why PRASA was allowed to be in a state of ruin, and also indicate who should be held responsible and who benefited from this unacceptable state of affairs. So as a result of that, of course, the President considered the report, and the position that was taken was that SIU be afforded the opportunity to continue with the investigation, and the scope be extended to cover what the Zondo Commission wants or recommended to be covered. And we then started a process to process a recent proclamation which covered this scope. And the proclamation is 153 of 2024, which was gazetted on the 16th of February 2024. And this would cover various focus areas, including the maladministration and the governance part, which would really indicate what were the governance failures at PRASA, over and above some of the focus areas that we focusing at. As I indicated, there was an investigation that was conducted, and that's what the last bullet point indicates that there was a proclamation R51 of 2019, and we will update the committee on really the outcomes of that investigation. I'm going to now, at this stage, just hand over to my colleague, Ms. Kasibe. She is the Chief National Investigating Officer. All these investigations are under her. Of course, the teams under her guidance. So she'll really take the committee through the presentation. As you indicated, Chair will regard the presentation as read. We'll probably just really go on the focus areas, what the status of the investigation is, and the outcomes, and of importance, as you said, Chair, what are any other systemic issues that we are coming across, so that when the committee does the on-site visit, could take that into account. Thank you.
Thank you. Over to you.
Thank you, Chair. Good morning, Chair. Good morning, honorable members, HOU, colleagues. In the interest of time, Chair, I will just zoom into the issues. In terms of our mandate, we are in the main required to investigate the Shivambo releasing contract, the Siangena contract, and then we were given additional responsibility by the board to look into the fraudulent liability claims that were processed and paid by PRASA, as well as then the employment of ghost employees. Then overall, we're looking at irregular, unlawful, and improper conduct by the employees of PRASA. That is now subsequent to the issuance of Proclamation R154 of 2024, which is the recent one. We also received allegations from a whistleblower alleging irregular awarding of contract of general overhaul and maintenance of trains. This contract was part of the old proclamation, which is R51 of 2019. However, at the time, the SIU did everything that we could to get documentation. The documents were not available, but at this stage, the whistleblower had provided a number of documents to us. So given the new allegations which fall within the scope of Proclamation R51, we have now reopened that proclamation, even though the report has been submitted to the President. Okay, just a background to the investigation. We have noted that both Shivambo and Siangena contracts have been set aside by the courts. The investigation, therefore, will focus on identifying irregularities in the process leading to the award of both contracts, the officials and the board members responsible for these irregularities, with a view of achieving certain outcomes, be it referring evidence against directors and companies, those that may have contravened the Companies Act to the CIPC, also identifying evidence that points to the Commission of Criminal Offence to NPA, referring evidence of contravention of tax legislation to SARS, as well as then the evidence to professional bodies, as well as then the special tribunal in cases of losses that were suffered by PRASA. Now, Chair, we're starting with the Shivambo releasing contract. In terms of this, we have already alluded to the fact that the contract now has been set aside by the courts. However, in terms of our recent investigation, we have identified 28 entities who received payments from Shivambo. And we are now investigating these entities to identify if there were any services that they rendered to Shivambo for them to be entitled to such payments. In this instance, Chair, we're just gonna touch on the key entities out of the 28. Shivambo was contracted by PRASA to provide 88 locomotives to the value of 3.5 billion rand over a 5-year period. So in terms of this contract, PRASA had already paid Shivambo an amount of 2.6 billion. From the 2.6 billion, Shivambo then paid Ufolslo, who is based on a 100% subcontracting agreement between Folslo and Shivambo. So only 13 of those locomotives were delivered to PRASA. Then during its engagement with PRASA, the SIU was then advised recently that PRASA is in discussions with the liquidators of Shivambo with a view of obtaining the 6 locomotives which are already in South Africa as part of payment in distribution, and then as the 17 locomotives which are still in Spain. So those negotiations are still taking place, and we understand that they've been paid already by Shivambo as a dividend. The SIU then will monitor the engagement between PRASA and all other concerned parties. On analysis of financial information, then we identified that Shivambo then paid the remaining 776 million to 28 entities, including 16 directors. One payment of 246 million was made to SARS. The team is engaging SARS to determine if the amounts due and payable to SARS in terms of the tax laws have been made and received by SARS. The investigation team also identified a payment of 110 million rand to Company A. The reason we are not naming the companies is because we are still investigating. These companies have not been charged, so we are not going to be revealing their identity. So 110 million rand has been paid to Company A, of which one of the directors at the time of the payment was the former chairperson of the PRASA board. The process of following the money is ongoing, and the investigation team is approaching the entities to obtain relevant documentation, as already alluded to. The team also identified Company B, which received 1.5 million from Shivambo, and one of B's company directors was also the director of Shivambo at the time. This member, this director had in the commission indicated her willingness to circle and pay back the money, and the SIU is in the process of engaging the company with a view to recover the funds. We are also looking into the relationship between the former GCEO of PRASA, the director of Company C, which received most of the monies from Shivambo, and the director of Shivambo. Then moving to Siangena. Siangena, we only identified 10 entities which received payments from Siangena. The same process is taking place. However, I'm not going to just go into the background of how the contract was then awarded to Siangena. Safe to say that Siangena was contracted by PRASA for an amount of 5.6 billion for the supply of integrated security system at various stations from 2010. PRASA paid 3.3 billion rand to Siangena. As part of the court judgment, the parties were required to evaluate the work that was done by Siangena to at least get to understand the value for money, and that process is still ongoing. We are still awaiting the final report on that process. The SIU will study the report and determine if it should appoint its own independent evaluator to assess the report and advise. The SIU has, however, noted that Siangena rendered the services as far back as 2010. So conducting the value for money assessment would be a challenging exercise due to factors such as age of infrastructure, vandalism, and possible depreciation of assets over time. So those were the issues that we are considering. So we also identified 2 properties in the name of the former GCEO that were bought during the period in question. Property 1, it was purchased for 11 million rand, paid for by Company D, which is a subsidiary of Siangena, to a Company E, and later paid to Company F, which then paid the 11 million rand to purchase the property. So the director of Company F is linked to Siangena and also linked to Company D. Then there's a second property. This property was owned by the former GCEO, and the purchase price was 1.8 million. This property was later revalued at 3 million. However, it was purchased by Company G for 6.8 million. Company G is linked to Siangena and its group of companies. Company F received a total of 22 million rand from Company D. After the award of the Siangena contract, the director of Company F bought a house for 2.8 million, and the evidence obtained indicates that the negotiations leading to the purchase of this house were conducted by former employee of PRASA, who was also involved in the Siangena SCM process during the tender process. So the SIU is of the view that the above transactions were simulated to disguise gratification to the former employees of PRASA. Payments to the tune of 557 million were made by PRASA to Siangena, and these payments were later paid to a Company I, which is owned by a politically exposed person, and these payments and relationship is under investigation. Now we're moving to focus area 3, which is fraudulent liability claims. In this focus area, we received 4,937 claims from PRASA, and all these are still under investigation. So in terms of these claims, PRASA received and recorded 3,809 liability claims with an estimated reserve value of 1.4 billion. And the estimated legal fee on these claims was 477 million, giving a total liability of 1.9 billion rand. Furthermore, between 2016 and 2020, PRASA recorded 829 open potential claims with an estimated claim reserve value of 70 million. And the estimated legal fee reserve value was 1.7, and giving a total liability value of 72.7 million rand. The claim liability value of all open matters at current is 4,638 claims, as from 2010 to 2020 financial year is at 1.5 billion. Estimated claim reserve at 479 million, and the estimated legal reserve fee giving PRASA a grand total value of open claims of 2.04 billion rand. The SIU found that between 2012 and 2024, PRASA Insurance Department recorded, processed and paid 51,000 payment records, which translate to 299 insurance liability claims, giving the total liability paid to 1.4 billion rand. So we received 405 files from the insurance division of PRASA. 226 files are open for investigation. And to date, 76 matters have been identified and undergoing legal review in terms of the SIU processes, and in order to be submitted to civil litigation for consideration to prevent loss or recover monies on behalf of PRASA due to the following. The first one is the incidents that were claimed for never occurred. Injuries were not consistent with the claims. Claimants, they were not being aware that the summons have been issued in their names, no records of submissions at hospitals. So there is a potential saving of 57 million and a potential recovery of at least 1 million that emanates from the cases identified as set out here in ANT. NPA and Legal Practice Council referrals of fraud and misconduct will be made as soon as possible once the pending reconciliation of evidence is complete. Then we move to then the ghost employees. There is, Chairperson, a PRASA report emanating from the project called Ziveze, which identified 1,277 employees as ghost employees. We started with this investigation, and out of the 1,277, we've already finalized 620 in terms of this. And we are still, the 657 is still outstanding. We have done a verification process of employees identified in the Ziveze report in 3 provinces, Gauteng, East London, and KwaZulu-Natal. And the results, therefore, are set out in the table on the next slide. Out of the ones that we have investigated, we can confirm that the employees who were not were identified in the 3 provinces as ghost employees are those employees who either resigned at the time, or their contracts expired, or they are on retirement. So we have not at this stage identified any instance of any ghost employee from PRASA, from the 3 that we have done. Then we're looking at maladministration and governance issues. So this investigation has recently been initiated. We are looking at the appointments of a board. We are looking at the process of appointing the PRASA board at the relevant time, and also the subcommittees of the board. We had 5 subcommittees that were in place during the award of Chivambo and Siangena. And Chair, maybe if I may just like a little bit explain this one. We are looking at maladministration and governance issues in relation to the period, or then in relation to the allegations that we are investigating. So we are looking at both Chivambo and Siangena tenders, and then these subcommittees, 1 to 5 as listed, they are also a focus of our investigation, because these were governance structures that ought to have at least prevented the losses if they were in. So the SIU, we have started to evaluate the board induction pack for financial year 2011-2012. We are doing a comparison of shareholder compact and terms of reference, including subcommittees in the process. We are doing a lot of reviewing of all the processes in this area. I don't want to go through each and every aspect, Chair, in this area. But what we are looking at, maybe looking at recommending systemic recommendations based on the gaps that we are identifying in the assessment process. And then we, once we have everything, we are going to consolidate and send that to the relevant authorities. So basically, that is that. And then when we do deal with our general observations, we'll then advise the committee on what were our general observations in terms of these ones. Now, Chair, I will then step down on the OR 154 of 2024 and then move to the progress on the R51. This is the proclamation that was issued in 2019, and the investigation in this one has already been finalized. And I will just then go straight, Chair, with your permission, to the findings and outcomes. We were tasked with 8 matters relating to the procurement of security services. And in terms of this aspect, our investigation is complete. We have found that there was an irregular confinement of 7 service providers to the value of 1.5 billion. NPA referral on the former accounting officers, and we referred on the contravention of PFMA, read with section 50, 51, and 55. Then the next one was Truma Intense Royal Sechaba Vipstaya, Black Hawk, Ilanga, and advanced detachments. Then in this one, our findings are that the former accounting officers, together with the GCPO and GCFO, have all resigned or dismissed by the time we finalize our investigation. However, we managed to submit 2 disciplinary referrals against 2 senior officials of PRASA at the time. And then we also referred 3 referrals against 3 PRASA officials and 1 SAPS officials who used to be employed at PRASA at the time, and these were all submitted to PRASA. We also had a SARS referral on 1 matter of Ilanga, and an LD was signed by by the company name V for 122,000 rand. Then on these ones, civil litigation could not be considered at the time because PRASA became aware of the irregular confinement during 2016 and 2017. So we had an issue of prescription in this area. Issues of delay played part in the inability to recover any monies. Lack of crucial documents contributed to the inability to quantify losses. So general overall maintenance services. In this one, we identified 8 investigations, and the status is that in the 1 matter of Opiconsivia, the investigation is complete, no overpayment or no corrupt relations were confirmed. But in terms of then the other matters, the 4 contracts, then the appointment was based on irregular confinement memorandum. Contracts with service providers were not available for investigation. Invoices were paid, and when the services were, as and when the services were rendered. So there were no outcomes in the first one because nothing was wrong. Then the other 4, we referred NPA referrals against the former accounting officer for then the contravention of PFMA. And then again, in one of the matters, Isipigeni, investigation is complete. Payments made prior to the contract period, irregular condonation for the payment of 32 million made above the contract amount of 90 million. So disciplinary referral against senior officials were submitted to PRASA. Then there is a CIA contract. Again, the investigation is complete. there was a variation order of 71 million rand there. Quantification of payments concluded, and the variance of 64 million between contracts amount, the variation orders and payments made by PRASA to service providers. Then the status on the CIA, 6 variation orders as well. Then the officials were no longer employed by PRASA at the time of our disciplinary referrals. The company applied for voluntary liquidation. The supplier development program, 6 matters were identified. And in terms of the first one, active power, matters were investigated under 2020 secondment, and recommendations referred to PRASA for disciplinary proceedings against an employee. Then the Nandisa Melissa, 4 NPA referrals against the service provider, its director, and 2 officials of PRASA. DPCI is busy finalizing their investigation. SIU is working closely with DPCI in these matters. There are 5 PRASA disciplinary matters, and 4 of those employees were dismissed. On the Conogon, investigation is complete. NPA referral was made on the irregular confinement referral against the former accounting officer. Then the Bakara one disciplinary referral against a senior official of PRASA. And then David Sekhobela, allegations could not be substantiated as no adverse findings were made due to insufficient documentation. On the Wave Amateur, irregular confinement referral against former accounting officer was made. And then the outcomes on the early detection of cable theft solution. The investigation in this area also is complete. We referred 3 disciplinaries against PRASA officials for irregular approval on variation orders that were above the normal permissible contract percentage. Then the travel management, NPA referral against the former accounting officer was then made. Then supply of mobile transporters, we were looking at Semele trading, and the investigation was in respect of then that contract with a value of 18 million rand. That investigation is complete.
Sorry? No, he's staff here in Parliament. Okay.
Okay, thank you, Chair. So, okay, in terms of Semele, there was 1 DC against 1 official of PRASA who was a business unit manager, and also 1 SARS referral. On the procurement of forensic services, there were 2 entities that were identified. Then the first one, the contract value was 17 million rand. We identified 24 million rand irregular variation order. The investigation is complete, and we also did not manage to refer anything in any disciplinary in this area, because the employee is no longer employed at PRASA or any other state institution for the purposes of this one. In terms of the second one, Vreckman's attorneys, the contract payment to the value of 170 million rand, the investigation is complete. We identified that then there was an irregular appointment, 3 POC, though the value of money was realized. So I've already, Chair, given, on each one, the status of each investigation. Although we have identified a number of irregularities throughout the investigation, which resulted in the disciplinary referrals against those officials that were involved. A number of officials had already left PRASA, and we could not make any recommendations for discipline against them. Most of them are not working for government at this point in time. Civil litigation was not pursued due to lack of documentation to quantify the losses suffered by PRASA and all the debts that prescribed at the time of the investigation. PRASA was made aware of the irregular transaction through a number of investigation reports resulting from this investigation, but they also failed to act. Then in terms of the summary of outcomes, in terms of this investigation, we only had that AOD that was signed for 122,000. We referred 13 disciplinary referrals, 10 NPA referrals, 2 administrative referrals to SARS, and then we submitted our presidential report to the president in December 2023. As already alluded, Chair, this investigation has been reopened, especially now that we have received new allegations and we have now received some documents in some of the areas. Then in 2020, we concluded a secondment agreement with PRASA. And the secondment agreement only had to investigate material irregularities identified by the Office of the AG, anonymous allegations made by whistleblowers, and irregularities identified by the Werkman's attorney reports. In total, there were 18 focus areas identified for investigation under the secondment agreement, and 1 matter was reported by a whistleblower to PRASA. All these investigations were completed, and the SIU is currently supporting PRASA in the disciplinary proceedings. In terms of this agreement, on all the 18 matters were investigated and submitted to PRASA, and of the 44 officials or employees, only 33 were still employed by PRASA at the time. Disciplinary proceedings are ongoing, and we are testifying, so we continue to support PRASA in the disciplinaries and then in the matters that were referred to CCMA. Then this is just general observation on PRASA on all the proclamations, secondments that we have done. There is no policy or procedure that's in place on the liability claims. PRASA has mitigated the risk of claims through an insurance policy, and the agency pays sum of 30 million rand per month as a premium. However, it is in the SIU's respectful view, the insurance with the underwriter by PRASA, it's not fit for purpose, as none of the 4,000 claims that we reported on were covered by the underwriter. The underwriter only covers claims above 100 million, and yet most of the claims that are submitted to PRASA, they fall below this threshold. There is poor record keeping. Most documents are reported lost, misplaced, or stolen. Ghost employees are being verified as if as a process was not properly coordinated and communicated, which led to a lack of verification process at the time of the investigation. General non-compliance with legislation is very prevalent in this entity. Then that goes to our risk chair, where we are unable to unearth adequate evidence pertaining to investigations in order to determine lawful and unlawful conduct, and most records are missing, stolen, or lost. Then there's this dissipation of assets, and also there is liquidation of companies that were involved in this. So in terms of our project timelines, we anticipate that this new investigation will be finalized by 31st March 2025, and then the project cost as of today, in terms of the new proclamation, we have already billed PRASA 3.5 million, and they've paid nothing. That brings us to the end of our presentation, Chair.
No, thank you, Honorable Chair and Honorable Members. That's the PRASA presentation, both the new proclamation and the old one, well, I say the old, the one in 2019. Honorable Chair, as you can see, really that the main issues arise out of procurement. And the current proclamation focuses also on, major, which is procurement processes, Shifambo and Siangena, and those were major procurement processes at PRASA. And Chair, you'll see that even the 2019 proclamation investigation, the main focus areas are around procurement. Now, for purposes of PRASA business, each and every area of that procurement process was meant, obviously, to achieve a certain business improvement, whether it's the procurement of locomotives, of overhauling and maintenance, and so on. From where we sit, and as we also conduct now investigations around governance failures and maladministration, will really also pronounce on the failure of management, executive, and the board, and that part we've indicated what has happened in the old proclamation, the 2019 one. There's been a number of actions that PRASA took. There was a number of senior managers that were dismissed and so on. But as my colleague indicates, there's serious issues with document management at the organization, whether deliberate or neglectful. But what I have said to the teams quite often is that we shouldn't really just end there, Chair. We shouldn't just end there, because that's the easiest way of frustrating investigations. So we should go further. We should go further and say, under whose custody were these documents supposed to be, and what is it that was done to keep this document, and if it wasn't done, who should be held accountable for that? Both at management, executive, and board level. Because in various investigations, Chair, it becomes easy for the organizations or state institutions just to say to us, we can't find the documents. And as I say, that's the easiest way of frustrating investigations. So the instructions to the teams now is that we shouldn't end there. We must dive deep and hold everyone who is accountable for having kept the documents to account, including the board. There's indications, because that's the procurement part, and which is really the bigger part, and that really needs to be monitored and to check whether there has been, controls and systems put in place to monitor the procurement space. Of course, where human beings are involved, there's a measure of collusion. That part is the part that really needs to be monitored as well, from the process of risk management, checks and balances, and so on. Now, there's a part, of course, there's also procurement involved in it, but the insurance space. Insurance is a big area, big business area of PRASA. And as you could probably have related, Honorable Chair and Honorable Members, there's fraudulent claims. And that has the elements of the medical legals that we presented here before. Fraudulent claims, and even at the other presentation we'll be doing on PRASA, there's elements of that. Now, the insurance space is quite big. So it really needs to, be monitored at PRASA. Now, the ghost employees, this is more human capital management, but again, there's elements of maladministration, corruption as well. that system needs attention as well. There's quite a number of verifications that the teams will be doing, but it's an area, it's a vulnerable area in the organization where there would be fictitious employees, so to speak, those who have retired, those who have resigned and so on, but sort of still kept in the system one way or another. And that's either deliberate or neglectful, as I say, and the investigations will bring that out. So, Chair, that's really the overview that we are putting forward to the committee. We will continue to do the investigations. The investigation has been reopened, as the colleague has indicated, and we will report accordingly once the outcomes are reached. Thank you.
Thank you, Advocate Matibi. So we're going to, I think it's more efficient to just move on to the next presentation. However, I do want to ask a clarification question on this, and then later we'll get the members. I just need to understand slide 19, bullet point number 2, where 1.8 and some money billion was paid to Foslu based on a 100% subcontracting agreement between Swifambo and Foslu. I just need to understand what that means. Does that mean PRASA contracted with Swifambo and Swifambo subcontracted Foslu to fulfill the requirements of the tender, which in effect means Swifambo was just a middleman who otherwise could not do the work? Would that be correct? They did not, because you don't contract with somebody else to do 100%. You can procure on different components of the tender and that sort of thing. So I just want to understand that this is what this means.
Honorable Chair, I think your observation is accurate, and my colleague can come in. This is a serious anomaly, where then there was no need for Swifambo if they could subcontract 100% from a work to be done perspective. Why is it that we contracted Swifambo if they couldn't do the work? But let me allow my colleague to add on.
Yes, Chairperson, you are both correct. Swifambo was contracted Foslu 100%, subcontracted Foslu 100%, because Swifambo didn't have any capacity to deliver on this contract.
Yeah.
Okay, all right, thank you. So I just have one, and another, actually we can deal with the other ones later. That just jumped at me, because the 100% subcontracting was just unusual. Okay, thank you. Can you please proceed then to the next one?
Good morning, Chair. Good morning, Honorable Member. I will be presenting on RAF. Also, I'll skip the background and all other issues. I'll go straight into the focus area that we are investigating. We do have 5 focus areas that we are investigating. The first one being duplicate claims payments made to attorneys and claimants and sheriff and change of mandates. The second focus area is the procurement and tender irregularities, where we're looking at fruitless and wasteful expenditure. The focus area number 3, we're looking at payments made to a service provider in terms of rough act or contract awarded. And focus area number 4, we're looking at invoice submitted to RAF, including bills of costs. And focus area number 5, we're looking at fraudulent claims. Then, starting with focus area number 1, that is duplicate claims payments made to attorneys. The investigation focus on losses incurred by the state, where it's caused by duplicate payments made to several law firms or attorney. From March 2021, which also include unlawful acts of appropriation. These duplicate payments were allegedly effected by the sheriff who executes upon writs of execution and receive funds on behalf of the instructing attorney. The RAF has a payment system which dictates that when a claim offer is accepted, whether by settlement or by the way of court order, such claim will await 180 days before it is paid. As a result, an attorney will then attach the RAF bank account by way of writs of execution served by the sheriff, causing the RAF bank to effect payments in terms of the rates upon the 180 days when it lapses. And the same claim will be paid again, thus constitute a duplicate payment. And the SIU is investigating 102 law firms, which includes the sheriff who received the duplicate payments from RAF, approximately 340 million. When approached with the evidence, several legal practitioners have opted to cooperate with the SIU investigation in defraying of their indebtedness by signing the acknowledgement of debt from approximately amount of 340 million. The RAF and SIU has managed to recover some of the funds, and to date the SIU has signed AOD to the value of 70.9 million, with actual cash recovery to date amounting to 41.5 million. Their standing balance is on the total value of AOD continue to attract interest, as and when they are not paying, the interest go up. And the SIU investigation has also revealed that the total of 276 million was paid directly to RAF by the legal practitioner. As we approach them, some of them, they pay money to SIU, some they decide to pay money directly to the RAF. And based on the above, it therefore means that 340 million, an amount of 317 has already been recovered. And the investigation into this focus area is complete. The SRU is currently rendering legal litigation support and computing interest on the amount that is recovered. Then the SIU has referred evidence which points to the commission of an offense against 12 law firms or legal practitioners to the National Prosecuting Authority. And the referral currently are with the DPCI for further investigation. And SIU has found that there were attorneys who have received duplicate payments have since been struck off the roll. Some have been suspended and others have since passed away. And SIU is working together with the LPCE to appoint curator bonies to recover all the monies that has been taken from RAF. To date, 5 practicing practitioners have been referred to LPC, and change of mandate by the claimants on the implicated practitioner is handled by the appointed LPC curator bonies, and an update were provided by the SIU to the LPC. There is one matter before the LPC wherein there is a dispute on the quantum, that is 2 million differences, and the SIU, LPC, and RAF have met to resolve the impasse, and the meeting to finalize the provisionally is set for the 20th of September 2024. Then, still under duplicate payments, we're also looking at the financial institution, which is the banks. The rates were served on the banks in order to attach RAF bank accounts. This is after the 180 days has lapsed, and in the instances where rates was served on the banks will deduct the rates amount into the RAF bank account, transfer it to the suspense account in order to satisfy the rates of execution. To adhere to the provision of the State Liability Act, the amount in the suspense account will be kept until such provision are adhered to. SIU has since established that there are substantial monies in the bank's suspense accounts that are not dispersed. As such, this money are to date being retained by the banks, not retained to RAF. And according to one of the major banks, the amount currently held in the suspense account in respect of the rates amount to 15.4 million. And the total sum is held in respect of the judicial attachment that were served on them by various sheriff in relation to the RAF account. The reason for retention of such money are subject of investigation, which are still ongoing, and the SIU is considering litigating on this matter with the few recoveries of the money, with the view of recovering the money from some of the banks. Block payments, the SIU reported previously on the block payments to the value of 482 million for attorneys due for payments by reason on the RAF internal investigation. On the above amount, the SIU noted that a matter marked by RAF Treasury as blocks due to RAF internal investigation were incorrect. There are instances where a law firm will be investigated by RAF for bills of cost, and RAF Treasury will block all matters related to that law firm, thus prejudicing the claimants. This block amounts are accumulating interest which RAF will be liable for, and this may have implication on the financial statement of RAF. Then focus area, we look at the procurement and tender irregularities, which is fruitless and wasteful expenditure. And the focus area deals with payments made as a result of the irregular procurement process followed by RAF. And SIU is currently conducting investigation into 7 contracts which were awarded to certain service provider by way of a procurement process. And among these contracts, there are procurement irregularities which were flagged by the Auditor-General of South Africa. Then the SIU has identified potential cash and assets to be disinvested or divested or disgorged to be recovered from service provider, and contract under investigation and with possible referrals to special tribunal for possible cancellation. There's one contract, number 1, which is amounting to 742 million, and matter is before the SIU Civil Litigation Internal Unit in order to consider referring it to special tribunal so that we can recover the money. That is in terms of contract number 1. Then contract number 2, which is a sub-license to the value of 1.8 million. Investigation is ongoing in terms of this contract. Then the contract number 3 is an office furniture, which is valued at 40 million. This one also investigation is ongoing. And there's contract number 4, which relating to the fleet, and also the investigation is ongoing. Contract number 5, it's an office building, 17 million. And the contract number 6, which is cleaning services, to the value of 12.1 million. Then when going back, claim backlog contract, here the allegation is that the contract was awarded irregularly or unlawfully, and the project was established. The project of this claims backlog was established in order to deal with RAF backlog, and the contract was awarded to 2 service providers, and as per the needs analysis, the contract was earmarked to reduce the backlog claims. However, when the contract was awarded, it included new claims, so it didn't deal with backlog, it started dealing with new claims. There were also issue of performance in this contract, and the contract was awarded to a consortium whereof one member of the consortium fell off during the contract. Therefore, they just continued with the contract, and the budget amount for the contract over 5 years was 742 million, and the actual amount spent amount to 312 million. And SIU found that in awarding this contract, RAF contravened section 217 of the Constitution and also the PFMA in awarding the contract. So we will be, this is the contract where we currently engage in the internal civil litigation so that we can take this contract for review at the special tribunal. The second contract, which is the sub-license, the allegation is that the RAF procure sub-licenses which is not being used, and the value of the license is 1.8 And the preliminary finding indicate that RAF is not using the set sub licenses. And SIU met with the investigation is completed, and SIU met with the RAF CEO, and the investigation is awaiting further information from him so that we can finalize the investigation and make appropriate referrals out of the investigation. Contract number 3, office furniture. The allegation, it is alleged that an internal audit report showed that 36 million office furniture contract escalated to 40 million irregularly. And also the legal opinion from the internal legal department indicated that the amount of the service provider agreement which escalated the cost was irregular and invalid. The finding is that the appointment of the service provider appeared to be irregular. The reasons for an escalation potentially fell outside the prescript. And so in terms of the outcome, there's a potential civil recovery and there's potential NPA referrals and disciplinary referrals. So the team is currently finalizing some of the outstanding affidavit, and once they are finalized, then we will be in a position to make referrals. Contract number 3, it is alleged that RAF did not follow the correct procurement process in acquiring the office building. For a period of 10 years, there had been a cancellation of this contract, and final rental was done by way of deviation. The interim findings revealed that due to procurement process were not properly followed in the procurement of the office building, it appeared that RAF went to great length to ensure that this building was procured. They've identified building and they made sure that that building is procured. The evaluation process was interfered with by officials who were not part of the BEC, and the interference amount to a review of the decision made by the BEC, and the reason encapsulated in the National Treasury support for deviation memorandum or letter is short of being a misrepresentation, as material facts were not disclosed to National Treasury when they asked for deviation. On this matter also, we are at an advanced stage where we are currently reviewing some of the final affidavit, and thereafter there's a potential where we'll be making a civil recovery and also NPA referrals and disciplinary referrals in terms of this matter. In terms of contract number 5, which is fleet tender, the allegation is that it's alleged that an appointed service provider failed to deliver vehicle as per the SLA. The preliminary finding indicate that RAF delayed in signing the SLA for over a year after it has awarded a contract, which resulted in the service provider losing agreement with their respective bank. And when RAF finally signed the SLA and requested the said fleet, the service provider was unable to deliver on time. And this matter stands to be finalized, and there's only one affidavit that is outstanding on this matter. And once we received it, we will be assessing the potential of making a civil recovery, NPA referrals, and disciplinary referrals. Contract number 6 is panel of attorney, where it is alleged that RAF canceled the panel of attorney without a plan. And in terms of the finding, RAF had a panel of attorney that represented RAF in court involving claim dispute. RAF has since cancelled the contract of the panels of attorney. The rationale for such decision is the subject of the investigation. SIU has noted that there has been an increase in default judgment issued against RAF since the termination of the panel of attorney. The total amount of default judgment issued against RAF for costs and fees from 2018 until second quarter of 2023 amount to 4.7 billion. A sharp increase in the default judgment is noted between 2021 and 2022, and there is a matter where a claimant was awarded a default court order amounting to 11.1 million, which RAF failed to honor on the time, and which led to amount accumulating interest worth approximately 500,000, which was paid out in respect of the claimant, meaning that the more the payments are not being made, then they increase the interest, of which it's gonna affect the liquidity of REF. And the SIU, we have interviewed the CEO of REF and the board members in order to understand the rationale behind the cancellation of the panels of attorney. And we are at an advanced stage where we will be wrapping up the investigation. And out of that process, there's a potential recovery, and there's also potential disciplinary and NPA referrals that we are going to meet after wrapping up some of the outstanding affidavit. Contract number 7, which is cleaning services and security. The allegation is that it is alleged that RAF awarded an expired tender for cleaning and security services. The preliminary finding is that RAF issued security and cleaning services contract in a form of a tender and RFQ. The SIU issued a notice in respect of the tender information on many occasions, and the SIU was provided with information that is relevant. And it is only recently that RAF was content that the information pertaining to this tender is allegedly said to have been affected by a ransomware attack which occurred in the server section of the RAF. There also, we are also finalizing the investigation where we are looking at the potential of the recovery and also referrals to NPA and disciplinary referrals based on the investigation. Then focus area number 3, we're looking at the payments made to service provider in terms of the RAF Act. The focus area has 3 involved payments made to 9 service provider by RAF in terms of this act. And RAF pays claims from service provider who have rendered services to the victim of motor vehicle accident. And these claims include inter alia ambulance claims, hospital claims, doctor's claims, and other expert claims. Then in terms of number 1, service provider who rendered services to the victims of the motor vehicle accident, it is alleged that the service provider had been overpricing for its services. The investigation is ongoing and no finding has been identified as yet. There is a possible recovery and NPA and disciplinary referral in this matter. In the event that the investigation find corroborative evidence, litigation for recovery and secret profits and wrongful enrichment will be launched before the special tribunal. The second one is various hospitals or doctor, expert, actuaries, and ambulances, where the allegation is that various hospital, doctor, expert, and actuaries or ambulances, it is alleged that the experts are submitting inflated invoice to RAF. And the SIU has gathered information and data in respect of such claims, and in some instances appointed experts to assist with the claims relating to overpricing by the hospitals. The investigation has also identified possible collusion between the RAF and employee of the service provider, and the investigation is ongoing, and there's a possibility also of recovery and disciplinary referrals in this matter. Focus area number 4, we looked at the fraudulent claims. Fraudulent claims, it is alleged that there was an attempt to change bank accounts of the service provider. On this instance, RAF received internal intelligence report relating to the attempt to change bank accounts of the service provider. Upon investigation, SIU established that RAF employee have made a bank fraudulent account change on the RAF system and redirected money meant for the service provider into their personal bank account. The amount found to date on the personal account of those employees is 1.9 million, and the substantial amount of 1.9 was used to purchase traveler's check. The SIU has made the NPA referrals on the persons of interest, and traveler's check cannot be traced as the bank that used to issue them is no longer issuing them. And the SIU is following the money depicted on the process on the interest bank account, and the SIU noted that the person of interest will use a salary as a reference in the bank account. Such salary ranges from 60,000 and below, and every 2 or 3 months, that's where the money goes in. And here also, there's a potential of recovery, and we have made NPA referrals, and also will be making further referrals to NPA. And there's also possible disciplinary referrals for other officials that we have identified that were responsible for such attempt to change bank account. Then fraudulent claims, it is alleged that there are fraudulent claims submitted and paid by RAF. The investigation cover all the provinces in South Africa and foreign claims. The investigation cover inter alia the following: both foreign and national claims, modification across the entire South Africa, and repudiated claims. SIU has completed the mirror imaging of the RAF claim system, and red flag has been identified by the data analytics, where investigation is to commence on various provinces. On this investigation, we will be looking at instances where RAF has made payments and they've recommended the modification so that it can able to accommodate the claimant's condition, like the ramp and all those things. So we'll be checking whether did such modification be made or not. So we managed to get the data, and currently we are identifying some of those red flags. Summary of general observations. RAF claim system has many modules, and the SIU IT experts are working on ensuring the integrity of data to ensure accuracy is not compromised. And there are attorneys who have since paid the money received in duplicate directly to RAF, and the SIU is investigating whether in such instance there are possible misappropriation of trust. What we're doing is that we are checking where is the money coming from. Is the money paid to RAF coming from the trust account or from the legal practitioner private account? If it's coming from private account, it means that they've misappropriated the trust fund. Influx of rates of execution, that is during the time of our review, attaching the RAF bank account whilst the settlement claim is already loaded on the RAF payment system. Thus, payments will be made in terms of the rates of execution. Therefore, these duplicate payments will be made to both sheriffs and to the attorney. The foregoing observation also reveals a lack or delay in reconciliation by RAF bank account. And although the investigation is ongoing, there is an indication that RAF may have made duplicate payments to other experts, like example, the doctor and other service provider. And RAF employees who are key to the investigation are no longer employed at RAF. And the RAF had 3 instances of ransomware attack that occurred during December 2020 and June 2021 and August 2021. Thus, some of the information relevant to the investigation was lost. And the SIU has noted high risk of litigation, particularly from the person of interest. An RAF claim system has many modules, like I indicated. There are instances where RAF block attorneys without payment, block attorneys' payment without any reason for doing so. And RAF has a tendency of not deleting user profile upon termination, which result in those profiles being used to commit fraud. And document management RAF is also a concern. In terms of the systemic recommendation, the SIU re-emphasized that this systemic recommendation were made on the basis of strength of our last COPA engagement, which was last year. There has been no communication whether some of this recommendation has been implemented, where we recommended a periodic bank reconciliation in order to prevent and detect possible duplicate payments. And prior to effecting any payments, they must perform check and balances on whether there had been any rates of execution on the claim, and also to review the claims payment process. Then in some terms of summary of outcomes, you'll see that we have made the recovery of 317 million, and we have made NPA referrals, which is 12 of them, and administrative referrals to SARS and blacklisting CIDB, it's 5, and we have submitted one interim report. Then in terms of the invoices, we have invoiced 8.5 million, and today the REF has paid 5.5 million, and there's 2.9 which is outstanding. And that's a conclusion from the presentation. Thank you.
Honorable Chair, as you said, we know the slides are considered as read, but those are the outlines of when the investigations will be complete. Without risking repeating what we have already said with the general observations and the systemic recommendations, there really seem to be areas where REF needs to really improve. Just this morning, I saw that there's a call even made by the minister for PRASA to reduce the backlog. And there's a contract which is under investigations, which was aimed at reducing backlog. And the finding that we are making, that contravention of section 217, slide number 30, it essentially means that they didn't, or well, our finding is that they didn't follow the procurement process. Now, there's a risk that that contract will be set aside, and of course, where there's a need to recover, we'll recover, but the impact on the business is immense. Well, there's other focus areas, Honorable Chair and Honorable Members, where you have really been presented to. The issue around duplicate payments by the legal practitioners, it's a worry. The practice, this 180 days practice where, they would attach, the ref bank account, and those are the kind of practices that if there's management processes, those could be avoided. I really don't want to represent. We have set out all the observations in the presentation, Chair. Thank you very much.
Thank you very much, Advocate Motibi. So I'm going to start on, for the first time, I'm going to start this way and go, yes, because the honorable members on this side are beginning to give me evil looks after the meeting, because they always last. But I just want to, so what we'll do, if I can ask the honorable members, so ask PRASA-related questions, or at least specify the entity you're referring to. My preference is that we start with PRASA-related questions and then go to REF-related questions, so that when the team from the SIU is dealing with the matters, then they can go in order. Start with PRASA-related matters and then go to REF-related matters. I just want to ask, and I know the Office of the AG is not presenting yet, but this is a simple enough question, and I've got 2 questions. One is, how prevalent is the problem of poor record keeping across the system? And I know that it might be a bit of an unfair question, but is it something you come across often? One. And secondly, which is a question I don't know, is destruction of documents and evidence, government documents, a criminal offense or not? So the concealment or destruction of government documents, is it something that is a criminal offense? The third is a general point. We will note it with the committee secretary. And that is, there appears to be a deeply systemic issue with the legal profession right across the board. I think if we quantified the cottage industry of claims against the government that are manufactured or defective in one or other way, right across all the agencies, national and provincial, I think the amount of money is potentially staggering. and it's something that needs to be looked into, and we'll find ways of incorporating that into our work, because we're supposed to prevent financial loss. Honorable members, so I will start here on my right. Given the time constraints we all have, can I just ask that we really get to the heart of the issues as quickly as we can, so that we can cover all the honorable members' questions. Honorable Maduna, I'm assuming that your hand is up. Honorable Madlana, would you like to ask? Honorable Neil May, Honorable Bila. Right. No, so what we're doing is you ask on both. So so I'll just sweep across like this. Start with, yeah, I'm just saying let's ask the questions in the order. So,
Can I ask, Chair? You say we must ask we must ask for both PRASA at the same time.
but I'm just asking that since they started with PRASA, so when you ask your questions, start with PRASA questions, so that when they answer, they can deal with all the members' questions relating to PRASA, and then deal with all the questions relating to REF when they respond. So you don't have to limit yourself to one.
I'm Chair, sorry. I guess it won't finish as you said. We won't be able to finish if that's the case.
I think, Honorable Skosana, we can. If we, you can. If we do what we did in the joint sitting, we had 2 committees, and everybody got to ask a question twice. We were just disciplined with the asking. Thank you.
I will be disciplined, Chair. Good morning. No, Chair, I will be short. I think I would have wanted you partially captured me on the 100% subcontracting. I've never seen something like that. I think in my years of practicing internal audit, it's for the first time. And it begs me, I have one question that perhaps I would ask. I'm not sure if SIU would know, but I'm hoping. So the money that was paid was this money paid direct to the to the person that Shivambu would have subcontracted to, or it was paid to the Shivambu? Because I'm trying to understand, if it was paid to Floslo, what would have been a documentation that would be on place, since the tender would have been won by Shivambu? So I'm trying to understand, because really, if that's the case, I think that is pure corruption, Chair. But I think that's my first question. I will be short, Chair. I think, in terms of the employment of ghosts, I think there's just one thing, Chair, that one must mention. I believe that, you see, in government, one thing you must appreciate, the systems in government, especially in South Africa, there's usually either an act, a regulation, that is regulating how things must be done in almost every process that you do, when it's either in a public entity or in a government process. I know that for instance, in human capital management, there are processes that guide in terms of when you upload someone, before you pay that particular person a salary, what documentation you must have. Appointment letter, the person should have went through interviews, and so on and so on. So these things confuse me when you say that they are cost employees, because it means that there's someone that would have signed an appointment letter somewhere. There's someone that would have faked that someone would have went to an interview somewhere. And I think all these people must be taken to task. It's not only about disciplining them. And I think we must even take it further to that, we refer them to the NPA. I think that's the comment that I would have wanted to make and check. In terms of these ghost employees, what do they have? How did they get into the system? Because besides that, it would mean then that the person that would be, I forgot what is that system that they usually use to make payments. Because even the person that uploads people, Chair, usually uploads, a superior approves, and then a superior reviews. Now, I don't get it when someone will just get a salary. How does it happen? I think, Chair, so I wanted to check that. I think, Chair, One thing that, in terms of the document management, I wanted to have a comment in the question. Perhaps because I believe that in each and every document, there's a process to get hold of it and so on and so on. Does SIU perhaps establish who's responsible for these documents that they end up not getting? Because I can tell you, Chair, there is no such a thing as a poor record management in government anyway. They just choose to not give the documents that they do not want to give. On RAF, I think, Chair, on RAF, my first comment and the question would first speak about the issue of perhaps to say that it's the legal professionals only would be incomplete, Chair. We must appreciate that in South Africa we have a problem of the health professionals that are corrupt, legal professionals that are corrupt, because in each and every, since I've arrived here, actually each and every report that I've heard of, always it does not leave these two. Doctors, they are always involved, lawyers, they are always involved, and this I then again say, Chair, it begs the question to ask the statutory entities where these professionals are registered at, what is their role? How can they be able to assist us to ensure that we keep this thing going forward? I think that is something that we must think around. And I would have wanted to say, because I think the advocate would have mentioned before that they are working very close with legal, with LPC. But I wanted to check in terms of the one that where doctors belong and these other professionals that you pick, are they coming to the party? What is happening around that? And I think my last question would have been, I see in many of these instances, a person gets a contract and I don't get it. Perhaps, advocate, you would teach me something new. A person, for instance, the one of Fleet, got a contract. How does it happen? We give you a contract and pay you in advance. And I see in many of these contracts, we've paid so much. The person would have delivered less than what we have already paid. For instance, the one of that was supposed to deal with the padlock had only dealt with minimal cases, but there's a huge amount of money that the person had already been paid. Now, according to my analysis, I'm trying to understand, Chair, how does it happen? We give you a tender, you sign an appointment letter, we pay you upfront, because in terms of the PFMA, MFMA, and many other prescripts, it's no longer allowed. That is something that used to happen long way before 2000. I think, Chair, basically that's that. I do not think there's anything that I'm.
As you land.
No, I'm actually done. I wanted to check the issue of reconciliations with RAF. Are they doing, because in their business, in their line of business, I would expect them that they are doing, well, it's usually recommended that you do monthly reconciliation, bank reconciliations, bank recons. However, in their line of business, because they're a cash business, that deals with making payments, one would expect that they are doing reconciliations, such things as weekly reconciliations, to check that all the payments that they would have approved through the process have been paid. And in coupled with that question, I want to check, how are they operating their bank account? They have a main bank account, 32 days, some accounts that they keep the monies for future obligation. How are they functioning their business? Because I'm trying to understand so that I can have an idea, Chair, where there are lack of adequate internal controls. Thanks.
Thanks, Honorable Madun. Honorable Madlala.
Thank you, Chair, and greetings to honorable members and the delegation. Speaking after Honorable Maduna is a privilege because there's no way I would exceed his time. So the bar has been set a bit longer. I wanted to first, we'll always want to do this, to encourage and to appreciate the report, the work done by the SIU, and in light of dealing with these matters. It's quite a huge task. But I think we are at the point in time where we are all called upon to stand in line and defend what is correct for this country. And we encourage that. We have many, symbolic men who stand to fight what we are trying to fight. It's a huge task, but it must be commended. because it turns the tide of history, you know. We are coming from a space where we had a government that believed that black people cannot govern, that believed that black people were incapable of governing properly a country. And it pains some of us who are also professionals in our own right to wake up to these kinds of things every day because we are validating their sentiments. And it's an embarrassment. It's actually spitting on the graves of those who fought for this democracy. So we come every day with passion to try and prove, because I'm of no conviction that we do not have capable black people in these institutions. But equally, on the same breath, I think we are taking a soft gloves approach every time when we speak about the inability or incapability in referring to blatant corruption and act of blatantly disregarding processes. At this age, we can't speak of executives where we'll recommend that they must implement the system, try and put this document, recording systems and all of those things, because I think we're giving them an easy way out to say, no, we need to be retrained. There needs to be a training on how to manage funds and all of that. We can't. We can't. We must operate from the premise that suggests that if you are in an executive level at a state-owned institution, a multi-billion institution, you know what needs to be done. We don't need to mentor and coach you about what needs to be done, because the human capital recruitment processes themselves should be enough to ensure that the right people are at the right positions. And I think at times that we're arriving at this mess because those processes themselves are infiltrated, you know. Sometimes boards and other people who are responsible for them get their friends into positions and they easily do what they want them to do. But I think we need to change that approach. I think we are implementing a soft gloves approach, and people can get away with saying, no, I didn't know, so we're trying to put in place this system. The record keeping is just a basic thing, as Honorable Madonna has said, you know. There must be consequences for those that fail to furnish the relevant documents, and they must be as harsh and carry the same weight as would have been carried by the possible outcomes of the receipts of those documents. Maybe as a recommendation also, as a request, is that in the report, for example, I was looking at the PRASA report, if we can get the timelines, for example, of when the recommendation was made to the MPA, to the NPA, or the recommendation was made to PRASA, so that we also need to have a traceable, you know, time frames of who is lacking in bringing matters to finality. We need to know when the matter was reported, put a timeline to it. This is when the report was concluded and sent, and so that we can know exactly who to actually deal with. And I think those are some of the issues that are very important and are going to help us, because we need a different approach to this thing of corruption. As I said a bit earlier, whenever we come here, you know, we are really overwhelmed by the scourge of it. So we need to take a more radical approach to it, where we need to make certain amendments to provisions. Let us be advised accordingly. Let the report speak to that, so that we can bring these matters to finality and stabilize our state-owned institutions. Thank you.
Thank you. Honorable Skosana, are you good to go, or you are not going to speak? Yeah, no, I'll just cover everyone in sequence. So please go ahead.
Yeah, no, thank you very much, Honorable Chair, and good day to everybody. Yeah, the disadvantage that I have is that I was outside, so I don't know how many members spoke and who spoke what. So that's why I was afraid of raising my hand, that I might be repeating something.
We can come back to you later if that's...
Now that I'm on the platform, let me continue. Chair, on the issue of ghost employees on the PRASA matter, because it looks like in relation to KZN, Gauteng, and East London, on that slide that was referred, there are those employees who are classified as ghosts because they were on the system while they were still working there, and some of them have retired and some have resigned. But now, is it an issue of record keeping that they are still there on the system but they are not remunerated? Or is there any remuneration involved that those people are still there and they are still paid? Or it's just that the system was not updated, so it's just an issue of record keeping and stuff like that? Is there any remuneration associated with those people who are still in the system if they are no longer, if they were employees but they are no longer working there? The second point is with regard to officials who had already left PRASA by when the SIU was dealing with this matter, so they could not make recommendations for discipline against them. So what are the powers of the SIU in that regard? If a person has left the employment of PRASA and that person is no longer in any state-owned entity or government institution, what are the powers of the SIU with regards to that? And then with regards to the insurance of 30 million rand that is being paid by PRASA, and you find that they only cover claims of 100 million upward, and it looks like most of the claims that are submitted there, they are below that 100 million. Don't you think that there's something that is not right there in terms of the acquiring of that insurance by PRASA? Because you've got such an expensive insurance, but it will only cover very few people, very rare cases, because cases of that amount, I think they will be obviously very rare. But here we are having an entity paying such an expensive insurance, then that insurance is unable to cover most of the cases that are being submitted. Is there no foul play there in terms of the entity acquiring such an insurance? Yeah, the last point on fraudulent liability claims. I see that total liability paid is about 1.497 billion rands between 2012 and 2024. And then the report there says there's a potential savings of about 57 million rands, but there's a potential recovery of only 1 million rand out of the total of 1.497 billion rand. Why such a small amount that can be recoverable? Thank you very much, Chair.
Thank you so much. Honorable Nelmay.
Thank you very much, and good morning to our colleagues here. Thank you very much. I'm not going to talk on other areas that have already been asked. I'm going to come back on PRASA. This insurance fraud, I think really, now you've got your attorneys that we've now noticed is where there's been a lot of collusion, and now we need to start looking at the insurance companies and insurance fraud, because that showed up now in this report. But what I'm going to talk about is the qualifications of the executives. I mean, just recently we saw the chief engineer being, he was jailed for fraudulent qualifications. He was earning a salary of 2.8 million, friends with the CEO and everybody. I mean, when I was doing research, I just looked at the pictures. You can see birds of a feather flock together. You see them all in different places together. Now, what implications does that engineer have with documents that were signed off? He's not qualified. It was fraudulent, 15 years there. He signed off documents. Now, these trains that were ordered, their specs, obviously their specs would have, which is what we've seen coming through now, it has huge implications for engineering challenges. And we're sitting with that situation. And I wanted to find out, what are we doing about the challenges that have now come from a person who was supposed to check? And what are we doing about the checking of all those executives' qualifications? Because this is historical. I mean, you can look back. When I researched last night, I looked back at who's who and where it came from, you know, and the external influences from Dubai all over. It is mind-boggling, you know, that we allowed something like that to even take place. Coming to RAF, here we go. The same thing, attorneys and legal fraternity in systematic corruption. So what we've seen over the last week or two is systematic corruption from the legal fraternity and obviously supply chain management. It is absolutely coming to the boards and the CEO and all those that are on there. One, I think, is going to have to take a magnifying glass and start to look at that. One thing I didn't know is, what is the SAP licenses? What licenses are those? I saw there that they were paying for. I didn't understand that. And then again, the capacity of those running our SOEs and agencies. And then administration. Can the RAF, I was just checking, should there not be an administrator, Chair? Thank you.
Thank you very much. I'll just piggyback quickly on that. There was an amount referring to, relating to Vexmans. I think it was 170 million, or I don't know. It appeared to be a huge sum. When you answer, just say, it seems like a huge sum of money, but also says there was value for money. What time period did it cover? Was it several years, or was it 1 year, and so on? Just if you can let us know. Honorable Neil May, the minister, is coming here. She will tell us what must happen. Honorable Bila.
Thank you so much, Honorable Chairperson, and greetings to our colleagues, and greetings to everyone in the House. Chairperson, I was laughing alone here when the PRASA people were presenting. That word, Swifambo, is not Chivambo.
Hey, I was worrying about the former Honorable Floyd, feeling that he's being targeted in this committee. It's Swifambo, right?
Swifambo, referring to
Swifambo.
all fleet.
Swifambo.
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 Yes.
Okay, can we please?
So we can get ourselves in trouble when we say Chivambo.
Thank you.
Thanks so much. On RAF, on duplication of payments, which also involve our attorneys out there, I just want to check if it is not possible for the claimant himself or herself to go straight to RAF and claim, or to make the claim, instead of in need of a middleman or an attorney to can help. Because in some instances, you found that the person who is helping our poor community members are getting the bigger portion than the one who is affected on the road or elsewhere. So I just want to check if it is possible that a claimant can go straight to RAF and claim for himself or herself. Thank you so much.
Thank you, Honorable Member. Honorable Atkinson, I'm coming this way. Don't worry, you're next. This, no, your chance is coming. These members usually sit here patiently.
Don't worry, by the time we get to you, all the questions will have been asked, so it's fine. Yeah. Thanks very much, Chair, and thanks very much to the SIU. And again, thanks for what you're doing for our country and the money you're saving the Treasury. And I said that to you, advocates, when you presented to us on the medico-legal claims. And you're quite right that there's a sort of a golden thread between what's happening here and what's happening on PRASA as well. And that's where claims are made but are completely uninvestigated. I mean, you know, when you present on the medico-legal claims, you're telling us about people that have died or, you know, people that have never been to specific hospitals or whatever. You know, and the same thing here with PRASA, where we see that, again, claims are completely uninvestigated and that money is just paid out to people, and that in some instances those people don't even exist. So my point is the same as it was about the medico-legal claims. I do hope that once you've done your investigations, that there's a proper process put into place, that every claim that's done in future actually goes through a specific list of, say, 10 or 15 points by PRASA or by the insurance team at PRASA, and also with medico-legal claims. Because I think of a situation where I've got car insurance with a private company, you know, and the claim might be only 15,000 Rand, but I get a visitor from a loss assessor. They check to see whether it's been properly reported to the police. They phone the people to see that the accident actually happened. And they're for minuscule amounts of money compared to the millions that we're dealing with here. And there's absolutely no checking. So my point in this is thank you for what you do, but I just do hope that once this is over, that we don't revert back to a situation where we continue to pay out fraudulent claims with absolutely no investigation at all. And then the second point to be made is this issue of the vanishing documents, you know, that documents very conveniently are no longer available. And I think the only way to resolve this, and this seems to be a problem right across the government, is to digitize. You know, we deep into the 21st century now. The fact that we're just relying on paper really does leave us at a huge disadvantage, and it leaves us, you know, at the disadvantage of the people that have got bad intentions. So if all these documents could be digitized, it would be very difficult for people to not be able to access stuff. And yeah, that's my contribution. Thank you very much.
Thank you. I was tempted to tease you then, go to Honorable Mente just to upset you, but Honorable Scosan.
Thank you very much, Chair. You know, though I won't be able to finish this session because of another engagement, but I wanted to say this quickly. I'll be on the SIU findings and pending findings as well. One, I'll start by saying the issue of Shivambo, the investigation has been going on for many years. I'm not sure whether, but I guess the SIU is aware that there's a court application by PRASA at the High Court of South Africa asking the court to allow it to use the so-called trains. The PRASA affidavit signed by the acting currently GCEO clearly states that the so-called trains are switchable for network and could be used even on limited scale. PRASA is asking the court to allow it to take delivery of the remaining locomotive, you know, as a way to amortize the 2.6 billion which was paid for these locomotives. So the issue of public perceptions that those trains were not suitable for, I think those are your media. I don't want to call it Stratcom here, but I'll be honest to say, sometimes you read things which are not factual. You know, some of the journalists are more political more than anything else. And in fact, that confuses our society at large by saying Mr. Zivi is corrupt, and that character is going to sit with you for many years to come. So this issue of sensationalizing issues, for me, without basis, it's a serious concern. My colleague just said now that, you know, as black people, you know, in the past, people say that blacks are not capable. But I can rest assure you, you know, we had the UJ councillor there. They charged 14 million rand. 14 million. It's not about color, you know. It's not about color. You've got your Marcos Josta and others. There's many more. It's not about color. Corruption is corruption, even within the executive here, even within the MP here. Members of parliament, honorable members. Corruption is corruption. It doesn't have color. It doesn't have a character. Now, for us to even think that it's naive that perhaps it's only us. Some people I know, they want to get power back, but you know, it's going to be difficult as long as we are here. The purpose of this investigation of PRASA, I guess from the SIU point of view, I think you have to ask the tribunal to rule on this matter, how to recover this fine on this new application which has been made now. I think it would be proper, because if there's money missing, that money has to be recovered at all costs. But the investigation cannot go on forever. I mean, starting from 2018, I guess the time frames, perhaps the resources are not enough, you know, for investigators to do their job. Some will say that the findings were irrational because of the players from various accounting reliabilities and authorities. The board, as we sit here, under Nkwenyane, if I remember, I think there's Nkwenyane as well with PRASA then, you know. But clearly, I think Advocate Mothibi, this matters has to be finalized. I mean, we cannot go on forever, you know, investigating matters for over a period of 7, 8, 9 years. Some, you know, whilst we are still investigating, will pass on without, you know, accounting for their sins. Now, coming to the Siangena matter, I've seen on the presentation. In fact, I read on the presentation was sent on the 18th. I mean, on the 16th. On the Siangena matter, the High Court in Pretoria ruled that PRASA and Siangena should appoint an independent engineer to determine the actual work done by Siangena. The report of that independent engineer now has been placed before the High Court. The findings of the report of the independent engineer, like in the Swivambo matter, runs counter to the finding of the SIU. In fact, these reports prove beyond any reasonable doubt that the work was done and the service of infrastructure or equipment was delivered. The report, in fact, shows that PRASA got the best deal and even paid less for the Siangena speed gauge equipment. I'm not sure whether the SIU report have considered the report of this independent engineer. And if so, why do you continue with the witch hunt? If it's true, because some people view this investigation as a witch hunt. I'm not saying it's a witch hunt. The allegation made about this contract has been going on forever and ever. My last but one quick question. To the SIU, some people would believe that there's a double standard. If you remember very well, that the first proclamation implicated the board chair, Popo Mulife and Zoda Manasseh, who were responsible for the irregular appointment of the payment to Vexman attorneys. And Vexman attorneys was paid a whopping 400 million for the unlawful and irregular contract. But there's no consequences. Vexman, I never heard that Vexman would be amongst those companies which would be blacklisted. And as we speak now, those findings disappeared. That Vexman was paid 400 million. That findings disappeared into a thin air. The Auditor-General of South Africa in 2016 and 2017 made findings about these Vexman attorneys, which was irregular. When are you going to the tribunal and recover this 400 million? That would be my question. My last question will be, the abuse of resources by Vexman Wenzel and the cozy investigators operating at PRASA, milking the state resources. If their names pops up, what is your plan, again, to really make sure that Vexman as well account for all these irregularities? Because remember, Vexman, in fact, they were sitting in those offices for how many years? Almost over two and a half years. sitting in those offices. And indeed, the findings were there. I'm not sure about this second proclamation, whether really are you still going to pursue them. But indeed, it should not be look like there's a witch hunt against particular companies. But in particular, this one, I mean, 400 million is serious money. And the issue on PRASA, I guess the issue have to be clarified, whether those trains were really as proclaimed, you know, and as sensationalized by the media, that they were too big, you know, to be used. But we are seeing them now. We are seeing them on the rail. But out there, they are saying, no, these trains were too big, you know, for them to be used, you know, on our railway line. My last on the ref issue, I guess one of my colleagues said that the issue of doctors, lawyers collaborating, perhaps is the minister or is us as members that we should have a policy on that to say people should be paid directly. You know, not this issue of a third party like one of my colleagues said, that this money is somewhere, they disappeared somewhere on your trust accounts, you know, and these noble professions of legal people and doctors. And if you read all these things, sometimes you ask yourself, as I said, it's not about color. Even the society, you know, it doesn't matter whether we're educated or not. It means this thing is in a DNA of human beings. I can't believe that an attorney, an officer of the court, can really give someone, is paid X amount of millions, and is giving the victim not even a quarter of that money. 0.0% person where he's supposed to get 1,000 rand, he gives him 50 rand, he chows all the money. But I know perhaps that's criminality is not a matter of SIU, I'm not sure in terms of there's a thin line in that, but indeed, we can do better. Thank you so much.
Fortunately, Honorable Skosana, we are going to PRASA physically, and I hope you'll be there. We'll look at and touch those trains ourselves, so we'll get the answers. Okay, thank you. Honorable Kubek, welcome back.
Thank you, Chair, and greetings to the colleagues at SIU. Chair, I think on the SIU matter with PRASA specifically, I think my colleague here has asked a couple of questions that I wanted to ask myself, so I won't go into that one. I think the SIU team, Advocate Motibi, I think you guys need to be very careful with the perceptions that you guys are giving out to ourselves as South Africans, because at times it seems as though you guys are focusing on certain people or certain individuals in your investigations. Because I want to echo what my colleague, Honorable Skosana, just said on this thing with Versman's attorneys. He's speaking about 400 million. I'm looking at another issue here with 170 million that was paid to Versman's. And it's alleged that that the value of money was realized on that 170 million, even though it's not spoken now about how the tender was awarded. It was irregular. So the fact that it was irregular, does that now, and this is a question, does that now stop the irregular part of it and the realization of the value of money? Which one precedes which one? Which one is more important? Do we stop investigating them and stop asking for the money back from them, even though they are awarded irregularly, because now the value of money was realized? What happens there? I think that's a question, more a clarity-seeking one. And then the inability to unearth evidence with records missing, lost, or stolen, and companies being liquidated, and people dying or people leaving, resigning, and never to be found again. Another question, is that the end then of those investigations? Or is the SIU trying to look further into it to figure out, okay, after the missing documents, what then happens? Because clearly that document mismanagement at the entity, it's deliberate. People lose documents and they destroy documents so that they hide evidence. I think that's it on RAF. And then on PRASA. And then on RAF, the duplicate claims made to attorneys, claimants and sheriffs, amounting to 340 million. That's shocking. That's truly, truly shocking. If you've got sheriffs there, as in people who are supposed to be protecting the entity itself, accepting duplicate payments and claims, what is the, how does the SIU deal with that? And on the amortization, acknowledgement of debts, once these attorneys who are allowed to cooperate with the SIU have signed those acknowledgements of debts, is that the end? Once, okay, we found them that they're guilty, they've taken the monies, they've signed the acknowledgement of debts, what then happens to them? Are they arrested? Are they let go because they've now decided that no, we are going to be working with the SIU? What happens then? And then just lastly, of the 340 million rand, 317 million rand has already been recovered. I think that one is a well done on the SIU. I thank you.
Thank you, Honorable Kubeka. Honorable Mente.
No, thank you, Chair. Now, I only have two clarities. The rest will be clarified by the departments. Just two clarities to the SIU on the PRASA one, as on the matter of Swivambo appointment and the tender process thereof. Because if they didn't have capacity and they outsourced 100% of what they were appointed to do, did you get who appointed all those bid committees? What happened? How did they arrive at a point where they were convinced Swifambo has capacity? And then when Swifambo outsources the entire contract to someone else, what did the board do? I just want to understand, when you went into the offices and asked those questions, what happened? Because in my understanding, the board, once it picks up such errors, it would have intervened ordinarily as the authorities in the institution if the GCE is defeated by the bid, whatever committees that are there. The second one is, or before I go to the second one, because these ones of trains and everything that can be recovered and monies and everything, for me they are secondary because they are now remedies on how do we get our money back as a state. How do we then get that value? But there's something wrong, and I'm not understanding it at all. So then the second one is on this panels of attorneys at RAF. There also I have a big question. Once the panel of attorneys is collapsed, now we have a high number of judgments. Ordinarily, the process of RAF doesn't get to that stage if it's not engineered at the office. So it means the investigation should look at how did the system fail to a point where it gets to that default judgment. Because the panel of attorneys as well was not doing much, more than that it was trying to be extinguishing the fires of the failures of the system. But once there is a spike, someone is engineering the problem so that the spike brings back this particular thing that for me, it's a designed problem so that there must be a failure of this institution, and then we must bring these people to save the institution, which renders the leadership of the institution very useless. So I want to understand there, if what are these anomalies that you picked up? Because the spike would not just ordinarily go. Because when they collapsed the panel, they did have a system of how they are going to counter whatever needs available, as well as how they were paying the panel and all those things. Because the panel itself, Chair, there were shortfalls in what was happening and what informed the leadership of RAF to collapse the panel. They didn't just do it out of spite and all those things. They were informed by a practice and a pattern they picked up on particular cases going into the panel, and the panel having to work on same cases and build up and then payments and all of those things. But there is some engineering of a problem which must persist and push the state to say, no, the leadership is failing, number one. Two, we're losing money and the money shouldn't go there. However, the process of RAF says a file comes in, within a certain period of time, it should be finalized. If it's not finalized, then the lawyers go there. How do we pass this stage, and why are we not having people accountable to make sure that we don't pass that stage of finalization before it goes to court? So that's where the problem for me is, and I want to understand, how did you deal with that one? Thank you.
Thank you. Honorable Plase.
Yeah, no, thank you, Chair. I think most of the issues have been covered, so it'll be very short. I promise I won't compete with Honorable Maduna and Skosana. They are leading in that department. Yeah, no, Chair. I think, Chair, I like how the SIU phrase the insurance fraud as not fit for purpose. Yeah, but it's fraud. No, it's deliberate, Chair, because, I mean, you can't pay, and I think the premium per month is even more than what the claims are if we can get that report. So say, now you've got this insurance that you are paying, it covers a certain benchmark, but you still as an organ or as an entity still needs to pay us claims. And if we were to look at those claims, you'll find that majority of them are even lesser than the premium. So it's insurance fraud. It's fraud. It's a systematic fraud. Some people are benefiting from these premiums and everything else. So not fit for purpose, well, I get it from their side, but sometimes they just need to say these things as they are.
Like auditors, ne?
Oh, well, yeah. Again, the ghost employees, we ventilated this with the AG yesterday. I see the SIU says the Ziveza campaign was not properly coordinated and properly communicated. Again, was this a deliberate miscommunication from PRASA itself? So that they come back and say that they have not properly verified their employees. Was it do they find any deliberate misconduct from PRASA that the lack of communication was deliberate? Also, Chair, now with that, I think it's RAF now, RAF, with the duplicate payments from the attorneys, claimants, and sheriffs. Again, I see a similar medical legal claims kind of system approach here as well, where people look at the system, they identify loopholes, and they go for it. I see that when the SIU comes in, most of the legal practitioners, they come in, they sign off an AOD, and then we recover some money. But is that really enough in terms of now accountability? Do we end there? Once the person pays back, do we not refer them to their relevant bodies for further accountability? Because, I mean, we have found you, we see that now we caught you on an act. What then do we do after you've paid the money? And also, is there, just lastly, is there a proposal of the system? Because we are saying that the system with its 180 days allows for this duplicate. So did the SIU sit back and say this system allows, because this money that is recovered is paid back to RAF. Now they will come back and then it's going to be a cycle. So should we not propose a change in the system of payments? Has the SIU looked at that, and what's the proposal so that we can look into that? Thank you very much, Chair.
Thank you very much. Over to you, Advocate Motibi and your
thank you.
team.
Thank
Then you
you.
can
Yes.
just start with all the PRASA questions.
Chair?
Oh, sorry.
Sorry, Chair. Sorry, Advocate. You know, I think my last question, I did not capture it correctly, or I did not include it at all by saying, is the State Capture Commission on review? That was my last question. Thank you. Is it on the review? That's the question which I wanted to ask. Thank you, Chair.
Thank you, Honorable Atkinson.
Sorry, Chair, I only asked PRASA-related questions. Can I just pose just very quickly some
Yeah.
questions on
Yes, you can.
on the RAF? The other one I just wanted to ask the SIU was, apparently there's been a contract for the call center. I'd just like to know if that's been investigated as to what's going on there. And the other is that there's a story that only 3% of the claims that go through are properly registered with the Road Accident Fund, which does leave the RAF exposed quite badly for claims that might be incorrect, that they would have a greater difficulty in refusing them. And then lastly, as far as the backlog is concerned, you mentioned the backlog. Who's going to be dealing with that backlog? Who's going to be appointed? How's that going to be? How's that going to be run, basically? Thanks.
Thank you. Over to you and your team.
No, thank you, Honorable Chair. I'll indicate where my colleagues would possibly also come in. Honorable Chair, I want to really start off with an observation that was made by yourself and other honorable members, amongst others, the document management and the seeming destruction of documents. This is a phenomenon that we come across in various other state institutions. And as I said, it becomes an easy way to frustrate investigations across. So that when we ask for documents, they simply say, no, we can't locate the documents. And I think in the past, it's always just been, all right, you can't find the documents, it ends there. Now, I think when we looked at the situation almost about 3-4 years ago, when we met with the team, I indicated, or it could be even more than 4 years, when we implemented the new strategy, we identified that amongst others, and when I read the reports of the investigators, the reports, more often, they would say, we went into this institution, we couldn't find documents, we couldn't go further. Then I said, no, it really shouldn't end there. And I engaged the teams, including their leaders, that we should actually change the way we do things here. So that when we request documents or even subpoena the documents, and we are confronted with that kind of a response, then the inquiry must go further. The inquiry must go further to say, where were these documents kept, and under whose custody were they kept? Why is it that the documents were not safely kept? And in that way, determine further consequences, further accountability, now related to failure to keep documents. Because there are regulations, laws and regulations relating to archiving and document storages. Those laws need to be observed, and failure to do so, we should hold all of those who are accountable to respond and account. And this goes at all levels, whether it's management, executive, and including the accounting officers or accounting authorities, which are the boards in state-owned entities. So this is a situation, and we're really glad that if it's identified as a phenomenon, and Honorable Atkinson indicates that digitization should be the way, and as part of our recommendation, of course, we'll recommend that, but it requires a substantive state action across to say this is really how this problem needs to be addressed. Honorable Batuna, the 100% subcontracting, I would like my colleagues to come in terms of actual payment, because the contract was awarded to Sui Fambo, thank you. The subcontracting was 100%, which is really an anomaly. Anomalous, ironical. Now, in terms of payment, I would like my colleagues just to come in to say what the investigations has revealed, were the payments paid to Swifambo or the other company which they 100% subcontracted to. Perhaps as a matter of structure, Chair, I can give my colleagues the opportunity now.
Yes.
Let them deal with that, and then we can proceed.
Thank you, Chairperson. The payments were made to Swifambo. 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 Swi. Okay. Okay, the payments were made to the main contractor, Chair, and who in turn had a 100% subcontract with false law. So PRASA paid the contractor, their main contractor, and the main contractor then paid to their subcontractor in terms of then the subcontracting contract. Thank you.
Thank you, Honorable Chair. And of course, now the payment issues would, whether ultimately the appointment, whether the appointment was irregular or not regular, would also impact on whether there's going to be recoveries and so on. And then the civil litigation would come in terms of, who do we really act against? But I would imagine it would be against the main contractor and the subcontractor in terms of recoveries. In terms of ghost employees, and the question comes up quite often, the investigation points out that there are those in the regions that have been indicated, or provinces, but in a sense, here the phenomenon is that there would have been, those employees would have been employed by PRASA before, and then they would either retire or resign, and so on. Now, the whole issue here is taking those, or stopping the payment further to those employees who resigned and so on. Now, it appears that the system does not have the controls, either deliberately or negligently. They do not have the controls to stop payments. Now, the investigation should actually go further to say if the payments were made to these employees who are ghost, either resigned or retired, where does the payment go? Does it go into their original pay account? And what happens to that money ultimately? That's what we would like the investigation to go further. And if there's anyone who benefits from those payments, either siphoning the monies from the accounts, then we need to know. So the investigation should give us those answers, and the investigation is ongoing. We should be able to report at the next occasion we appear. Does the SIU know who's in charge of documents? That's the point I made, Honorable Chair. We should determine who was responsible for the document management. Ultimately, the accounting officer or the board are responsible. So we'll need to check if there are any delegations of authority or whatever the case may be. But ultimately, the accountability goes up to the accounting officer or the accounting authority, as the case may be. So we should end up knowing who to hold to account. I do agree that in terms of professional bodies, yes, we have had interactions with the Legal Practice Council, and we are satisfied that they are taking action against those implicated legal professionals. We haven't really had physical interaction with the, say, South African Medical Association and so on, but we do refer formally. We have had meetings with LPC. We haven't had physical meetings with the medical associations. We are aware that they do consider our formal referrals. Perhaps there's merit in cases where we really can call on them, and possibly the committee could consider that. How is it that they can help us in this plague where the professionals are committing such fraudulent activities? The issue around the backlog, I think the contract on, this is ref. We'll come back to the ref questions.
No, maybe
can
you
I
can
just
just,
proceed?
yeah, because I'm looking at time,
Oh, okay.
so just
All right.
really fly through all of
the issue around the backlog, the contract has been found to be irregular. It has not met the procurement process. And the question, I think it came up as well from Honorable Atkinson, that who's going to do the work now? From where we sit, our role was to investigate the allegations that the contract was awarded irregularly. We've reached that point. The contract will be set aside. Now, operationally, is for the ref to start the process and ensure that they do the process appropriately and appoint whoever would be suitable to do the work. So that would be the part where ref would have to do the work. Is ref doing reconciliations? I think this is something that I would like the investigators to also come in, because from where we would expect that should be done. But I would like the investigators really to say, up to now, have we zoomed into sort of banking reconciliations? Does ref do that or not? Perhaps I can allow either Mr. Lekgetho or the lead investigator to comment.
Good morning, honorable members. Thank you. My name is Rediban Lebopa. In terms of the reconciliation, we have noted that there are challenges, but as part of our systematic recommendations, we have advised REF to also look into that, to ensure that there are reconciliation that are performed, and also go to an extent of ensuring that when payment are effected prior, they should also check if there was any writ of execution, so that they must avoid those duplicate payments. Thank you.
Oh, thank you. So that would probably sit in one of in our recommendations, because it is to be expected from any organization that in their banking systems there should be a reconciliation process. Failure to do so, it's really maladministration on their part. Honorable Madlala, are we taking a soft approach or soft glove approach? I think we do take that comment, and that it's really, we understand it as a call to say, you know, consequence management has to be meted out in whatever form. We're saying here that, you know, in the main, yeah, you would see that the consequence management takes the cost of recovery of monies, cancelling contracts, disciplinary action against officials, NPA for those who are guilty of criminal offenses, and to other regulatory authorities. So I think the call here is to make sure that there is even-handedness and that the consequence management is meted out the same way in all these categories. And some of the questions came up that if the attorneys pay, sign acknowledgement of debt. Because again, it's an easy way out, so to speak. If they've got the money to pay, they will sign acknowledgement of debt, and it would be an easy way out. And so it shouldn't end there, and it does not end there. The acknowledgement, the acknowledgement of debt, and we do sign an acknowledgement of debt not without considering other factors. The factors is on the civil litigation part, which Advocate Vanara oversees, is that at all costs we would like to recover what's due to the state institution, number one. Number two, there shouldn't be any other damages that we are overlooking. Now, if we are satisfied that the acknowledgement of debt would deal with the civil litigation part of recovering the monies, then we sign that, because it saves legal costs that we would have incurred. We shouldn't incur legal costs unnecessarily when we could settle that part. And we do check with the state institution whether, you know, that meets the recoveries. But it doesn't exonerate them, and we've said it before, it doesn't exonerate them from criminal action or any other professional referrals, and we do refer them to professional bodies. So we agree that we shouldn't give them an easy way out. There must be consequences for those who fail to keep documents. We agree that. And I've indicated that is an aspect that really in the past, and we can agree that in the past, say 5, 6 years ago, it wasn't a focus area. People were let go. That if they tell us, no, there are no documents, we move on. No, it has changed, and we would like to make sure that those who fail to keep documents are held to account. The timelines for referrals, we do acknowledge that. Honorable Chair, we will go back and update the presentation where we that indicate if there are referrals to NPA, when, if there are referrals for disciplinary action, when were they referred, indeed, so that progress can be tracked. Honorable Skosana, I think the issue around the ghost employees, we asked about KZN, East London, and so on. In the main, as you would have seen on the slide, those were the ones who were in the system as employees, and they resigned. And it's just that internally, it doesn't seem like there's a system to really, or the controls, to ensure that when I retire or when I resign, then the human capital system should know or should stop payment. So the human capital practitioners should know that. But it doesn't seem to be happening. And the point I'm making is that the investigation should go further. If there's irregularities, if there's corruption here, we need to know. If the accounts are allowed to be alive, who is benefiting? Who is getting the monies that are paid to these ghost employees? The issue of record keeping, Honorable Chair and Honorable Members, I think we've dealt with that. Is an issue that the system was not updated? Yes, it appears so. But again, it's controls that are put in place. Is there a management override on the controls? That's what this investigation must tell us. Or are the controls ignored? That's what the investigation must tell us, and who should be held to account. The officials who left, I'm glad to raise this question, and I'm going to allow my colleague, Advocate Vanara here, to come in. Again, as we improved on consequence management, it used really to be just a practice before we really changed our approaches, that when employees leave, some employees would know that they are being investigated and they would resign. You know, and in terms of the law, resignation, of course, terminates employer-employee relationship. But we are certain, we are so emphatic that it shouldn't absolve them from other consequences, whether it's civil or criminal. And again, this now, and that's the point that we made some time back when we came, that those who resign and join other state institutions, that system, that DPSA needs to, that register that we reported here before, that register has to really be alive and help us monitor these employees who crop up in other state institutions. But from a consequence management perspective, I'd like to give Advocate Vanara just a moment to say, how is it that when you have left, how is it that we deal with the employees from a civil litigation perspective?
Thanks, Chair and committee members. Quickly, if the employee has merely committed a misconduct and left the organization, unfortunately, that will be the end of the matter. However, if the misconduct has caused the organization, the employer, damages or loss of money, or there has been some criminal conduct, then a referral to the NPA would be made. However, we will similarly move to attach the employee's pension benefit with the pension fund to which the employee belonged to, either, again, to save costs through the fund being approached to exercise its discretion to withhold the pension benefit. We don't pay costs. If the pension fund refuses to exercise its discretion, which they are entitled to do because they're an independent body, we are forced to go to court, to go and obtain a court order to preserve the pension benefit. That assists us when we go and recover the monies. We cite that official in the papers to enable us to recover the money. But of course, I need to make the point that at times the amount or the damage or loss suffered by the employee exceeds the pension benefit that we've attached, and we look at other properties that we can lay hands on, and if not, that becomes the end of the matter. We also, as Advocate Motibi indicated, refer these employees to professional bodies, because some of them are highly professional people who belongs to professional bodies, and therefore they are referrals. Thank you, Chair.
Thank you, Honorable Chair and honorable members. The insurance, the exposure to insurance risk. Yeah, I call it insurance risk. So the risk of defrauding insurance. It really looks like it's a vulnerable area in various state institutions. And we have identified it as one of the focus areas at PRASA. And the investigation really should really go on and uncover the real nature of the exposure. the issue around how the insurance process or the insurance program run in the state institutions, Honorable Chair, honorable members, because there would be claims processes, and we would expect that the claims processes are processed by, well, if they are digitized, they need to be monitored. If it's fraudulent claim, I think a point was made in this committee before that if you claim from an insurance, there's some checks that are done before the insurance pays out. We don't seem that in the state institution that those processes are robust enough. The underwriters, what is their role? So it's really a field that needs to be unpacked, and to a large extent, as we investigate this area, we'll probably need experts as well, so that we can make appropriate recommendations. But we have identified, there's fraudulent claims, injuries in trains that do not exist and all of that. So the issue around fraudulent claims is a problem. And of course, those who are involved, those who are either professionals or lawyers and all of that. The issue around the qualifications of executives, I think it's really, really important. The reference to the engineer at PRASA, the investigation really has to look at that part as objectively as possible. And we know that there's been a conviction. But that part, and this is where the civil litigation would also come in, the extent to which the individual, due to the misrepresentation, has caused damages, has caused losses to PRASA. That part must be quantified and must be quantified appropriately. We know that he's serving a sentence, but we have to do our part on the civil litigation part. If we need to cite him in the court papers to recover, we need to cite him. The issues around the trains that were bought and all of that, the investigation will uncover, of course, together with PRASA, whether there was value for money or not. And again, my colleague, Advocate Vanara, wanted to make a comment on just generally on the issue around value for money. Because here, there would have been a business need to purchase trains, and PRASA would have depended on certain officials to ensure that the procurement is appropriate and that PRASA gets value for money. Now, when we investigate, we also go into whether the state institutions got value for money. And it's a legal inquiry. So the legals would work with the investigators to answer that question. It's an objective inquiry which requires an objective answer. And we will reach that response. I think my colleague is fine, but really just to indicate that that inquiry will be held and an appropriate response, an appropriate answer will be given. Sorry. The REF, the SEP licenses. I think there's a question around what the SEP licenses were for, and perhaps I would revert to the investigators here in terms of what they were used for, and whether they were used for that purpose. Yes.
Thank you, Honorable Chair. The sub-license was procured for human capital and particularly for performance management system. So it was not used.
So you're saying the system was procured and then it was never used?
Correct.
Oh, wow. Okay.
Thank you, Honorable Chair. That's the finding there. The issue around duplicate payments, I think it's on the ref side. We have raised this in so many ways with ref, and the recommendations with regard to 180 days and all of that, those would be made to ref. It is for the Road Accident Fund to attend to this situation, put in place processes and capabilities such that they avoid duplicate payments. We have indicated to them the basis on which the investigation pointed out the duplicate payments. So we do expect that they would put in place controls to avoid duplicate payments. Is it possible to get the claimants to go straight to ref? Really, I think this ideally should be the case, in as much as we have said in the medical legals that the claimants, we should at all costs or as far as possible eliminate intermediaries, eliminate middle persons, middle lawyers, middle doctors, middle anyone. So that the state should be able to assist the public directly. The state should be able to create the capacity to assist the public directly. So that's really, I know that's the policy realm. We can only recommend, but we are of the view. We are of the view that, the process of the state should be able to enable direct assistance to the public, and that probably requires policy intervention. So similarly, the issue around checklist in terms of payments of claims, similar to the comments made on the medical legal side, the payment processes really just require additional attention. The process needs to be either remapped and capacity needs to be created to monitor the payments such that we don't, as state institutions, lose the monies as it was indicated. The issue of Swifambo, yes, I think we did indicate in the presentation that we are aware that the courts have ruled already on this, and we've got a focus. We've accepted that they've been, the court have made rulings, but there are focus areas that we look at, whether there has been maladministration, whether there has been any processes that failed, and again, the investigation, the new proclamation is informed by the outcomes of the Zondo Commission, which indicated that there needs to be further investigations, and the investigations are ongoing. So when next we appear, we'll give adequate and pointed findings of what has become. I think one important issue is to note that we do agree, Honorable Skosana, that the investigations cannot go on forever. The 2018-2019 proclamation has been concluded and the report was submitted, save for the allegations that we received recently. That would be reopened only for that purpose. But otherwise, the 2019 proclamation is concluded. The 2024 proclamation was as a result of the Zondo Commission, and we will ensure that we speed up the investigation, reach the findings as supported by evidence so that there's finality. The issue of Werksmans, and I was checking with my colleague quickly, the contract was found to have been irregularly awarded. So it is very important to note that. And the investigation, I know, because I was informed that even the the chair of the previous board was interviewed. And if we have reached finality on that, perhaps the investigators can indicate, but I expect that there would be some finding after the interaction with the previous board. Do you want to appraise the committee on where that process?
Thank you, Chair. We have gathered all the information in relation to this appointment of Werksman, and there are still some of the documents that are missing, whereby we are at a point where we need to pinpoint the exact responsible people that were involved in the appointment of Werksman. But we did identify that Werksman also subcontracted other forensic investigation that worked together with them in terms of producing a quite number of reports that they produced to PRASA. But I think that we are at a stage where we are trying to identify, and it's good that we have opened the investigation because there are some information that are coming on board. And in that process, then we'll be able to identify who is really responsible for that irregularity. Thank you.
Can I just ask that, because I'm also mindful of time, that one of the things you do, and maybe we'll kind of square with the AG's office, can you, we might send you a couple of questions for written response, because I also need to understand what was irregular about it, and a bit of background on what the work was for, because like I said, you know, initially I assumed it was just legal services, and then I understand there are also some investigations. We need to understand what was irregular about it, and also an explanation of why the conclusion was there was value for money, because it's an amount that jumped at me when I saw it as well to a law firm. Okay, but I do want us to get to give the AG's office a chance. So if you can try and work through the.
No, thanks, Honourable Chair. There's quite a number of questions that are, but I see some of them were really repeated. Be careful about the perception created that we are targeting certain people. Honourable Kubega, we can assure you that we will do our work as objectively as possible. We would not want to be misdirected by any perceptions out there. Our investigations are really allegations based. The findings have to be supported by evidence. And to that extent, we really don't want to mess up. And because we know that we are being challenged in the courts, in the special tribunal, so we don't want our findings to be found to have been flimsy, irrational, and all of that, because that our reputation is at stake. Thank you. So we will really not do that. Werksman's contract, I think we spoke about that. Document destruction, we addressed that part. The duplicate claims that are shocking, I think we looked at that. We expect that we'll work with REF. We make recommendation to improve on that. And AODs, what's next? I think I've addressed that we don't just end at acknowledgement of debt. There are other consequence management related to these firms. Honorable Mente, the issue around Swifambo outsourced 100%. How did the bid committee satisfy themselves that Swifambo has got capacity? I'm not sure if you're able to comment just quickly in the interest of time, whether that you're still looking at that or have we finalized that part? And then the issue around the panel of attorneys at REF, look at why the spike in default judgments. Okay, yes. Whether there's some human engineering here, whether it was deliberate, that, you know, whether is it deliberate that the default judgment spikes. I would like to give the team the opportunity to comment. If we haven't reached that stage, we'll take that into account and make sure that as we investigate, we look at that part. Do you want to comment?
Thank you, Chair. We are still looking at the procurement process, but What we can say at this stage is that there were just failures by the committee to pick up glaring issues, especially on the part of these irregularities and inadequacies in terms of the Sufambo bid. This includes the bid tailoring in this case. So we are still busy collating all the information in terms of the committees and also the approvals by the board. At what stage did they felt it was necessary for them to approve the bid? So once we are done with that process, we'll then provide a report on that one. Thank you, Chair.
Right. Thank you. The issue around the collapse of the panel, that REF had a system to mitigate whether there was, have we reached a stage where we have discovered whether there's human engineering? If we are still looking at that or not, Mr. Lachet.
Thank you, Honorable Chair. We are still looking at that. We are wrapping up the investigation. We are currently interviewing previous board and all the people that were involved so that we can understand the rationale why this didn't happen. So we are at that level where we have not yet come to that point to make that conclusive decision. Thank you.
But as I say, Honorable Chair and Honorable Mente, we will take that into account so that we are aware that there hasn't been any deliberate human intervention here to engineer the default judgment so that the panel can be reinstated. You know, we'll look at that. Honorable Blosse, insurance not being fit for purpose. I think it was more around the insurance program that PRASA has to make sure that the insurance that they acquire or the insurance that is in place is fit for their purpose in terms of claims that they would usually receive or claims that they are covered, the exposure that is PRASA is exposed to. The fact that there is fraud in the insurance, I think we are agreed that there is insurance fraud. And as a result, there is a call to review the insurance program. Honorable Chair, or the last one, whether the commission report is on review. Honorable Skosana, I really can't formally or authoritatively confirm that. We can check. We have had the reports that, you know, those who were implicated took the report on review or not. We can't at the moment confirm formally. We can check that.
Yeah. So I think the process is what you take on review is a specific finding pertaining to you. You know, because the commission had different issues and entities and so on. I think we should check as the committee. I'm not aware that the entire report has been taken on review. However, there are instances where people are challenging the findings against them, and then the courts will have to make a determination.
Chair? Perhaps I was supposed to quantify it by saying there were 11 applications which were made about the State Capture Commission, known as Zondo Commission. There's 11 applications in the High Court. That alone tells you that there's issues about the commission. But Chair, before I leave, I just wanted to say I found it very strange that the same people who were prosecutors, they are now joined SIU, like Advocate Pretorius SC, Chuckleson as well, who were representing some other and Mutau SC. For me, it's a referee and a player.
Honorable Skosana, so there are two issues with your input. The one, you're directing them at the wrong entity. They haven't joined.
We'll call the NPA. I know.
No,
Chair
sure.
will do, yeah.
So, but the comment is not for them to respond to. So please.
Yes. What I was saying
joint
was
NPA, Chair, not
yes,
SIU.
the joint. True. Thank you.
Thank you.
You
Okay.
helped me. Thank you.
No. So I was just because I didn't want us to. So have you dealt with all the questions, Honorable Atkins?
The
There
call
was, there was
center-
a question that you had asked at the end. I just want to make sure that is dealt with.
The call center contract, I've just checked with the team. It doesn't look like the call center contract is part of the scope. If there are any allegations relating to the call center contract, the team would look at that. Thank you.
Chair, the issue of advance payment on contracts, are they paid in advance or what is?
Thank you for that. Do you want to respond on that? Were there any advance payment paid as you investigate? Because generally, Chair, the PFMA generally really does not allow advance payment. If any advance payment would have been made in this environment, whether by agreement or what, it would be against the Public Finance Management Act. I mean, I know we've got experts on PFMA. On PFMA here, they could also assist. Thank you.
No, I think there is a way of getting around getting an answer, Honorable Maduna. I'll ask the researchers to just find us the answer. This is in respect of the contracts at PRASA. Yeah, I'll ask the researchers to find that information for us, because it's historical information. And the matters were ventilated in the court, in the litigation, to set aside some of the contracts, and also at the commission. So the researchers will find it. Advocate Motibi, I think we need to release you. I am looking at the time.
Thank you.
Thank you very much to your team. We'll send you further questions for written response. The Auditor-General's presentation is 22 slides, so it's not long. So what I'm going to ask is, we're not going to get to answers to the questions. Okay, so while you are setting up, we'll do a quick body break. We need to be back at 5 past. Then you do your presentation. Please be finished by 30:30. The members ask the questions, then we'll get a written responses. The reason I'm doing it this way is that we are going on oversight. It's really important that we hear what the AG has to say. If we have further questions, what they also do is to allocate people to accompany the committee when it goes on oversight, so that they can assist us. But I think it's really important that we at least hear the voice behind the information, so that we can be properly equipped when we go on oversight. But thank you very much for the presentations. I'm hoping that we won't see you for some weeks, so that you can go and investigate instead of sitting here. But thank you very much. We really appreciate your service. We know that it's work between yourselves and the AG that happens in the background and so on, and there are many, many challenges to that work. But I want to wish to echo the sentiments of various members of the committee from all the political parties who've commended the work that you do, who've offered their support to the SIU to do the work of the South African people, and I also echo the same sentiment. So thank you very much, and also for always availing yourselves.
Chair, sorry, we need to find a way to capacitate the SIU to be able to prosecute. I don't know how we're going to do that.
That's for the committee's deliberations. So thank you. But thank you very much. So shall we please be back here in 5 minutes? Let's just take a quick body break. Then we'll get a download from the AG's office. Honorable members, shall we please take our seats? Is the team ready to go? You ready to fire from the hip? Okay, thank you very much. Let's just give the members 1 minute to settle down. Thank you. Over to you.
Thank you so much, Honorable Chair. I just want to greet you all, Honorable Chair, honorable members, advocate, and the team from SIU, my fellow colleagues from the Auditor-General. My name is Nompakamo Matanzima. I am the business unit leader that oversees the audit of Road Accident Fund. And today I have my colleague here, my fellow colleague, Lwazi Kuse, who is the audit senior manager in charge of the audit of Road Accident Fund. He will be the one who's going to be taking us through the presentations of today. As you highlighted earlier, Chair, we will take the document as read and highlight the key salient features on the document and any other systemic issues that you want to bring to the attention of the committee. But before we do so, I just want to highlight the presentations today is focusing on the audit outcomes of 2022-2023 financial year end. We have not, we will not be briefing you on the latest audit outcomes for the financial year end 2023-2024. And the main reason for that is because, one, those results have not yet been tabled. They will be tabled on the 30th of September, and then the BRRR process runs, and then we will come back and brief the committee on those latest results. So that's what I just wanted to bring you to the attention for that. I think you asked us a question at the beginning while the advocate was presenting in terms of if there is any prevalence in terms of the poor record keeping that we are seeing as Auditor General. But I do want to highlight that in terms of the Section 55, subsection A of the PFMA, the accounting officer, that section requires that the accounting officer as well as the accounting authority must keep full and proper records of the financial affairs of the public entity. So it is important to note that failure to furnish those documents as part of the evidence on how the public resources have been utilized is the breach of that section. So yes, we have seen the prevalence as Auditor General because we are privileged of auditing all the spheres of government. We've seen that where most of the times that we see that way, we issue our opinion in terms of the audit opinion, disclaimed opinion, the adverse opinion, and sometimes the one where we issued qualified opinion, there is an indication that the financial information or evidence have not been submitted in those areas. So that's how you'll see. I'll just hand over, with your permission, Chair, for Lwazi to take us through the presentation. Thank you.
Thank you, Paul. I call a Paul. Chairperson, greetings to you, greetings to the honorable members. As indicated, my name is Lwazi Kuse. I'm responsible for the audit of REF. Chairperson, it is a privilege and honor to address the committee. Although one has a number of grievances, as I was sitting there, Chair, I was looking at the watermelon, but the Chair engineered an outcome where I could not get to the watermelon because we only had 5 minutes to set up. Thank you, Chairperson. Taking the presentation as read and mindful of the fact that the presentation deals with matters up to the 22-23 financial period, one will certainly try, Chairperson, also to assist the committee so that as you conduct your oversight visits, we equip you, we empower you with some of the insights that we have as coming out of our audit. We always start with our mission and vision statement, Chair. We exist as a supreme audit institution to strengthen the country's democracy. And this we achieve by enabling oversight, accountability, and obviously we do this through the work we perform, which is audit-based in nature. Our vision is to be a relevant Supreme Audit Institute. And our relevance in this instance, Chairperson, I think coincides with the fact that we continuously reflect on the way we report, the way we audit. And we always ask ourselves the question, what more needs to be done? And having reflected on that, in 2022, the AGSA then took a decision to adopt a new strategy, which we call Culture Shift 2030. That culture shift strategy in the main focuses on shifting public sector culture to one that is characterized by improved audit outcomes, but equally characterized by service delivery. Because often the public would ask the question, AG, we hear that institution A or B is clean, but we don't see service delivery. So how do you link your messages and your outcomes to the lived experiences of citizens on the ground? And the culture shift strategy then responds to that. And in the presentation we have today, we have some messages that seek to address the questions around REF's performance insofar as service delivery is concerned, insofar as their core mandate is concerned. In order to shift the culture, we are mindful of the fact that we will not be able to achieve this on our own. We will need to work with various stakeholders. We've identified key stakeholders, and the slide really just depicts the process through which we will be shifting the culture. The expectation is that the culture is not going to be shifted in 1 year, but progressively over a period of time. If one reflects on the slide, we reflect on management and the role that they have to play in ensuring that they improve audit outcomes, in particular at REF, the internal audit committee. We also reflect on the oversight structures, the coordinating departments and entities. And in the middle there, we highlight some of the strategies and tools that we will be using. Of course, we will be performing the audits. We will be generating insights. We used to speak of findings and recommendations, but we've reflected on that and said more is needed. Perhaps we need to engage on the insights, a deeper understanding that we have of these auditees and what more needs to be done. And in this conversation, certainly we want to address that.
Mr. Kusa, can I say that so we see your colleagues a lot here, and they give us this presentation, so we won't feel wronged if you skip that part and you go on to slide, what is it? The one that's stagnation in the audit outcome over the administration term. Thank you.
No, thank you, Chairperson. Thank you, Chair. Chairperson, just shifting gears to the actual outcomes. If you reflect on the pictorial on the left-hand side, it depicts that the audit outcomes for REF, it was a clean audit outcome in 1920 with the green color. And there were then 2 years where it was disclaimed. And in the year that we are reporting, we are indicating that the outcome is adverse with findings. If you reflect on what is the adverse opinion about, essentially our opinion here is to say that the financial statements as produced by REF are not fairly stated. In simple language, they are not credible for purposes of one making informed decisions. And we do want to emphasize this, Chairperson, because often financial statements within the public sector are viewed through the lens of whether is it qualified or not, but at the same time, Some look at whether did you submit the financial statements or not. The challenge here, or the question that we are raising here is to say financial statements are an essential instrument for decision-making. And to the extent that the information that has been produced by the REF is not fairly stated, it therefore then impacts the key decisions that need to be made, whether strategically or operationally, around issues of their performance from one year to the next. The reason for the adverse opinion is around the accounting treatment that was adopted insofar as accounting for claims. REF adopted an accounting policy or a framework called IPSAS 42. That framework that REF has adopted is not consistent with the principles of GRAP. It is not consistent with the directives as prescribed by the ASB. The resultant impact of adopting a framework that is not consistent with the prescribed frameworks within the country is that, Chairperson, first and foremost, when you account for claims, you have the first event being the accident date, and ultimately the date when all administrative requirements or eligibility criteria requirements are met. What we are simply saying here is that REF is accounting for claims only at the time when all the administrative requirements of the claim are met, and thereby understating its exposure or its liabilities, because there are claims that are in the process between, of course, the date when the accident has occurred and the date when all administrative requirements have been met. So from a financial reporting point of view, the substance of the over-form arguments are not then reflected in the financial statements. What we then saw is that in the financial statements of 1920, the total liabilities were in the region of about 327 billion. By adopting this new framework, the total liabilities then reduced to about 34 billion. So you can just see the significance of that change in accounting policy. From a financial health point of view, in as much as we are expressing an opinion that the financial statements are not fairly stated, we are also indicating that there is an accumulated deficit to the value of about 24 billion, and this then brings material uncertainty over REF's ability to continue as a going concern. It is an understated amount, one must indicate. From a culture point of view, we do want to highlight that we are concerned, of course, with the fact that our findings and our recommendations insofar as accounting treatment, matters of compliance, have not been implemented timeously, and thereby creating a situation where that shift of the culture is not taking place, because management is essentially disagreeing with the findings that the team has raised insofar as the audit is concerned. In terms of root causes, overall we say that there is a lack of oversight regarding financial reporting, inadequate review of annual performance plans, and I'll expand further on the findings and the insights that we have insofar as the annual performance plans are concerned. We also speak to ineffective preventative controls as well as the slow responses. Overall, our recommendations are centered around ensuring that there is fair presentation of the financial position and performance of REF, but equally making sure that from a service delivery point of view, there is clear and measured outcomes in terms of what has been achieved. In slide 10, Chairperson, we just overall reflect REF's performance in accordance with the targets that were approved. In the year under review, the overall achievement is 91%. The target not achieved is the reduction of long outstanding claims. These are claims that are in the category of 3 years and more, and that target is 20% that should be achieved. What was achieved in the year under review was then 16%. 0.7%. The main fundamental issue, Chairperson, that we are raising, when you look at this picture, one would generally say it looks good. But we know that the lived reality of our citizens speaks a different picture when it comes to REF. And one then has to answer that question, what is that gap and why is it that the lived reality differs so significantly from what we are depicting here as performance? And in our findings, Chairperson, we have noted that there is a misalignment between the reported indicators in the strategic plan and the APP when you compare them to REF's mandate per the REF Act. The REF Act is clear that REF exists for the payment of compensation to those that are affected by road accidents. However, when you reflect on the APP and you ask yourself how many indicators directly speak to that and what is the level of performance, we then see that an insignificant amount of reporting is taking place that speaks directly to payment of claims. So we therefore, Chairperson, raised the finding that the indicators of REF are incomplete, but equally they are misaligned with their mandate. To make an example, Chairperson, if you look at strategic outcome number 1, which is financial sustainability of REF and the transformed REF, there are essentially about 8 indicators there. There's only one indicator that partially speaks to payments and how effectively that is being done. So you will then get this outcome where the overall achievement reflects outcomes essentially that are not in keeping with the reality on the ground. Chairperson, the other slides, I will quickly move through them. I do want to indicate that during the audit under review, we did identify material misstatements in the reported or in the submitted performance report. These were subsequently adjusted by the REF, and therefore we did not express any other findings. On compliance with legislation, the only compliance area that is in our auditor's report, and in the auditor's report, it's only significant matters that are reported. The only significant non-compliance is on financial statements, which is the non-compliance with Section 55 due to the accounting policies adopted on claims. Insofar as supply chain, we then reflect the irregular expenditure that has been incurred. The committee must be mindful of the fact that there was a change in legislation in terms of how you report on irregular expenditure. So if you look at the 22-23 financial year, it might reflect a value of 0. The reason for that, Chairperson, is that during the audit process, we did identify irregular expenditure to the value of 33 million. However, because REF disputed our findings, it then sits as irregular expenditure still to be confirmed. So I think that's the one important footnote to be taken into account here. Overall, Chairperson, we are also highlighting to the committee that the cumulative balance of irregular expenditure is about 444 million, of which 362 million is under investigation. These matters have taken long, and it's reflected in the number of suspensions in some of the instances where employees are on suspension for prolonged periods of time. So we are elevating this, Chairperson, to say that we need to strengthen the processes of consequence management and ensure that ultimately these matters and these investigations are concluded. Chairperson, the slide depicts the deficits of REF over a period of time. More recently, the cumulative value of deficits is 23 billion. It has increased by 8.4 billion from the previous year. Again, these are understated values relative to, of course, what it should be. Chairperson, also one just wants to summarize briefly that REF has disagreed with the findings we've raised on the accounting treatment. They have taken us to court in relation to the reports we've issued. The High Court recently, in April, dismissed REF's claim and ruled in our favor with costs. REF, however, has indicated its intention to appeal, and currently that matter is before the Supreme Court of Appeal. The SIU has presented, Chairperson, the call to action. I think the main areas, there is an opportunity insofar as performance management is concerned, because we need to ensure that whatever is published as performance of REF, it is firstly aligned with its mandate. The opportunity that we have is that there is a new strategic planning window that is opening, and we are therefore inviting the committee to reflect on the indicators that REF will be putting forward to make sure that they speak to, again, the performance of the institution. We also are calling on the committee to continue to assist us with resolving the disagreement pertaining to the accounting treatment, and also ensuring that there's effective consequence management, because over a period of 4 years, essentially, no movement has been made in relation to this matter. But furthermore to that, as I say, decision-making and the quality of decisions that need to be made around REF, the strategies that need to be adopted for the future are impacted by the fact that there are no credible set of financial records that will then support and assist the directions and the decisions that need to be taken. There are discussions around the legislative framework that should exist within the REF. Again, without financial information, without knowing the big or the extent of its liabilities, it then makes that discussion difficult to have. Chairperson, thank you for the time you've given. I now hand over to Ms. Matanzima. Thank you. I try to rush as much as.
Thank you.
No, no,
thank
son,
you.
you've left some time for some questions, and I've got like two, but yeah.
I just want to say thank you, Honorable Chair. We are ready to take the questions and the comments.
Thank you. So this is just a clarification, because this is obviously a big issue, the litigation between the Road Accident Fund and the Auditor-General, because these are both sort of either state or constitutional beings, and there should be at some point a way of resolving the issue, which is one of the reasons I think the minister should come here and kind of talk to the committee, because it appears to be just unbelievable to me that there is this ongoing dispute that potentially will go to the Constitutional Court, and RAF is an entity that is accountable to the ministry and so on, but they appear to be able to just do their own thing. It just, yeah, it blows my mind. So I just wanted you to just, because it's a technical accounting issue, to just simplify it for the committee, and I would say for the public record as well, because South Africans are interested in this stuff. What is at the heart of it? Is it, let me just share my understanding, maybe that will be quicker, and that is, it is at the point where in accounting terms, you recognize a claim as a liability. The dispute is whether you recognize the claim when it is lodged, or whether you recognize a claim and you enter it into the books when its validity is confirmed or something like that. And therefore, who validates it and so on. So if you can just take us through that little area, because we are going on oversight and we're going to go to the Road Accident Fund, and we need to ask questions of them and the minister when she comes here. So that's from my end. So can I just ask members that we really to the point, if there is enough time, because we have to be out here at 1:45, they might, otherwise they might then have to supply us with written answers. I saw you, Honorable Atkinson, Honorable Skosana. So let's do the same thing, but colleagues, please, let's, yeah.
Thanks very much, Chair. And is it me or go that way?
Sorry.
But I'm timing today.
No. I'm.
Can we keep it to 2 minutes for questions? 2 minutes per person.
Look, no, thanks, Chair. Actually, 2 minutes is too much. I just know two things, Chair, that I'm worried about on the report of the AG. That one, RAF has achieved 88%, but it's not a part of what is their core mandate, of which is to pay for claims of people who were in the accident. So the 88% to me is useless. I think that's my first comment. My second comment, I note as well that their deficit is increasing, even though they are understating their liabilities, according to where I stand and my understanding of the accounting. That's far. I think, Chair, basically those are the two things one would have wanted to speak on, and perhaps I want to check in their. Do they have some sort of a strategy for 5 years or so? If they do, is it aligned with the act, or is just things that are not aligned? Do they just prepare their own targets or indicators they want to meet easily? Thanks, Chair.
Thank you. Honorable Dlala.
Thank you, and greetings to colleagues. I just want to confirm one thing. The report suggests that part of the challenges is the failure to implement recommendations by management at RAF. And the CEO at RAF was appointed in 2020, so it means for all these financial years, it has been the same CEO. I just needed to confirm that. That's all, thank you.
Now you know why I want the minister sitting here on her own.
No, thank you very much, Honorable Chair. No, we welcome the presentation from the AG. Just two questions from my side. On slide 7, I see that in year 2019, 2020, I don't want to say year 1920, because when he said so, it sounded that he was talking about back then. Yeah, 2019, 2020, RAF got a clean audit. Then the following year, 2020, 2021, they got a disclaimer. So what happened actually? Just a 180 degrees U-turn from a clean audit direct to a disclaimer. Because normally, I think if entities fall or departments, maybe they will move from a clean audit to an unqualified with matters, to a qualification, adverse. But here, just within a year, from clean audit straight to disclaimer, what is the problem actually? Then the second question, which is the last question, slide 10. In that year, 2019, 2020, when they receive a clean audit, in terms of their overall performance, they were only at 57% when they got a clean audit. But strange, last year, 2022, 2023, when they got an adverse, in terms of overall performance, is 91%. Does it mean that year, when they got a clean audit, they were strictly focused on getting a clean audit and did not care about performance, and now they are more focused on performance, so they don't care about the books? What is happening? Why is such a disjuncture? Thank you very much, Chair.
Thank you. Honorable Nilmay.
Thank you. Thank you, Chair, and good afternoon. Chair, my question is just, do they have the same accounting package? I'm trying to get my head around that. The standard accounting package that government and all government entities have, in the sense of, so that the way we audit is the same standard in all the other areas. That was the one question. The other question was, if you look at the challenges they have and the audit, it doesn't seem to mix in some way. And that like you said, we'll get the minister here to ask if they can be litigated, that they can actually take the Auditor-General for litigation. Thanks.
Thank you. Honorable Pila, you good. Thank you. Honorable Kubek, are you good?
There we go. No, there we go.
Yeah,
Are you going?
Yeah. No,
No, I think I'm covered, Chair. What I wanted to ask, you've just asked it now, about the discrepancy between the lodged claims. And,
yes,
it's
the
that one.
provisioning. Yes.
Yeah.
Thank you.
Thanks, Chair. I know in your presentation you mentioned the fact that I think you said you didn't have sufficient information to be able to be aware of the kind of percentage of claims that have been paid. But it does appear apparently that the RAF haven't been paying medical aids and also haven't been paying foreigners as well. Now, it's nowhere in the Act that you can't pay foreigners, so they might well be going against the provisions of the Act. So I don't know whether you've picked up anything in your audit as to why apparently there's a large amount owing to Discovery. And then the second issue as well is this thing about the fact that only a small fraction of the claims that actually come through the RAF are actually properly registered with the RAF. According to some illegal board minute, that apparently a very large portion of them are actually not registered, so they don't appear in the actual numbers itself. I don't know whether you picked up anything about the fact that there's a very high level of appear to be rejected or not to be registered in the system itself. Thanks.
Thank you. Honorable Mente.
Hello, Chair, you've covered me just on the accounting standards in terms of the insistence from the RAF side that their accounting standard is suitable for their environment. And the AG says, no, that's not. At some point, we did get even I think a body that deals with accounting standards that came to concur with the statement of the AG in terms of accountability. But I think at some point we have to get to the bottom of this and reach its final conclusion, because we can't have two government sister entities taking each other to court over a simple thing of accounting standards. What becomes a way forward? Because if then a RAF insists, and to a point where we are focusing on the next court to deal with the outcomes of the other court, and we are taking our eyes off the ball in terms of what we are supposed to be dealing with, what becomes a proper intervention? It's been more than 5 years with AG and RAF having this turf war of accounting standards, because there's nothing else except this particular thing. How is it being remedied? I think that's a point where we are now. We need to look for an appropriate remedy. It doesn't help us to get AG complaining that they are not meeting this, yet they are insisting we are, but you are pushing us to a corner where we cannot do this, we can't do that, we cannot. There must be a common ground, because the people we are serving are no longer getting what is expected of both of us, and it renders the whole system now very useless. And then the second thing is the system of RAF. If you listened to SIU, it has a whole lot of loopholes. Even this thing of not meeting 180 days and everything, and the lawyers being paid double. There ought to be a way where a person can log in, get to a point. We've got it at SARS. I can file on and get all the required document requested through my email and everything. How are we doing in terms of advising, so that we don't get to a point where all these things are still a problem 30 years later in the democratic government? Thank you.
Thank you. Honorable Blose.
No, I think I'm covered, Chair, in the interest of time, but maybe one point is to say, when we go there, we must look at some serious systematic changes within RAF, so that we are able to make it more efficient. Yeah, thanks, Chair.
Thank you. So please note those down. We'll be in touch with you together with our research team to make sure that next week the committee members receive answers. Please be as not concise this time, as simple as possible, because we're not lawyers, at least I'm not, and so on. So please assist us in that way. The only comment I will make to the committee members is that I want to know which Sangoma the management there uses, that you can have deteriorating audit outcomes and endless litigation and you remain at your post with no consequence at all. And I think this is something the minister can maybe help us with when she gets here. But I want to say thank you very much to the AG's office. Again, going on recess, going to some auditing. And then we'll call you back later on. But I might say to both the AGs, particularly the AG when you go on oversight, we might ask you to come with us, at least one person, to come with us to assist. But we'll be in touch with both institutions with regards to our schedule and also in developing some of the questions that we need answered proactively by the leadership of those institutions. But thank you so much again. Thank you, honorable members. The answers will be distributed, the written answers. Thank you so much.